green juveniles, and green system on.
Good. And you should not be streaming.
I should not be streaming.
I'm gonna double check.
That would be awesome. And what about my packet for juveniles? Thank you, Madam Clerk.
You're welcome.
How are you this morning? I'm good. That kid back there gives you a hard time, just tell him.
So just let the judge know based on.
Whenever you and Ms. Moldoff are ready. Okay. And Ms. Berman, right? You here for the juvies?
Based on her juvenile partners, but at least you can get some, definitely the new content. If she needs to, maybe, I was just calling. That's why I said you see if she can't get evaluated.
Thank you.
Yeah, you're still on live, Judge. Hey, thanks, appreciate it.
So can I turn my,
You know, there's a delay, you know, Mr. Reed. Because I don't even sure that you're gonna be here.
ESO says there's a delay,
I'm looking.
but even if it's delayed, we're gonna be on eventually, and we don't wanna be on, right? Why can't I turn this off? Am I allowed to just turn the system off? Why does it have to record? Does it have to record for juveniles?
We have a record of it.
If I am streaming, IT needs to get up here and fix this, because this is gonna be constant, and if there's not someone who's alert enough to catch it.
Yes, Your Honor, it is streaming on the Sentinel's website.
Okay, so I'm turning it down, off, because I can't take the chance.
Can someone call Assistant Judge? We're trying to not stream live and it appears that we are. She's doing juvenile.
Good morning. You are here for your first appearance or magistrate hearing. My name is Betsy Benson. I am the judge presiding over the hearings this morning. Good morning, Ms. Chase. How are you? I can't hear you. Let me turn up the speaker.
Good morning.
Okay.
Yes,
I'm
I'm doing well. How are you?
I'm good, thank you, ma'am. I am appointing the Office of the Public Defender for purposes of this hearing to all of those who do not have counsel. If you believe you have a lawyer, please let the public defender, who is also a lawyer, know, and they will let me know, and we will try to contact that lawyer if that lawyer's not present, so that they can either appear by phone or get down here in order to represent you at the hearing. Also, if you think you have family members, or if there are family members present on behalf of anyone, just let me know that, and we will call for those people and hopefully get them to make whatever information known to the court that they want to make known. You might be asked to fill out a form later on for the public defender's office. Please fill out that form because, as I indicated, this is only for purposes of this hearing. Now, I want to let you know that you have the right to remain silent. And that means that anything you want me to know is best told to your lawyer, who is the public defender, because all of these hearings are recorded, and any time that the state attorney wants to use them against you at a later motion or hearing or trial, all they have to do is request the copy of the transcript or the tape, and they can use it against you. Because right now, you are giving statements that can be used against you later on. Just as an aside, that's also true for any phone calls you make from the jail. You might want to keep in mind that the state attorney can order those transcripts later on as well. We're here for me to determine whether there's probable cause to hold you over, and also whether there are terms and conditions of release that we would be able to utilize. So with that, I'm going to call a couple cases out of turn real quickly.
Judge, our Spanish interpreter is present.
Okay, if the Spanish interpreter would just hang on, we'll be with you as soon as we can. Ronald James Fonda, which is on page 14. Good morning, sir.
Your Honor, good morning. Joshua Dans on his behalf.
Mr. Dance, do you have anything to say regarding probable cause in this matter? I have reviewed the police report.
I have as well, Your Honor. At this point, we have no argument specifically to probable cause.
Okay, I do find probable cause on count 1, lewd and lascivious molestation with the victim under 12 and the offender over 18, and the same as to count 2. What say you as to bond, sir?
Your Honor, these are both life felony offenses. Based on the evidence contained in the affidavit by Detective Walker of the Lauderhill Police Department, noting specifically the specific allegations by the victim, but also a controlled call that was made where Mr. Fonda admitted to the offenses. The state would be seeking a finding of proof evident or presumption great for first appearance purposes only, and that Mr. Fonda be held no bond, so that the defense can seek an Arthur hearing in front of the assigned judge, where both parties can present evidence and testimony as they see fit.
Thank you. Response?
Judge, I do understand, obviously, while we're here for first appearance today, would the court at all consider, he does have his family present, there are a number of witnesses here, the bondsman's here. Would Your Honor consider hearing any testimony to consider a bond this morning?
Well, I would consider it if you want to wait until the end. But I am at this time inclined to agree with the state that the proper venue for that is before the judge who will be assigned the case.
I understand, Your Honor.
Okay.
So just on a separate note, are we putting this to the end? I'm not in.
No, Ms. Chase said, I believe everyone's agreeing up here that this should be held, this hearing, Arthur hearing should be held before the assigning judge.
And Judge, I think Ms. Chase wants to speak in a different capacity. If she
I'm
can
sorry.
Speak for just a moment.
Certainly, go ahead, Ms. Chase, I'm
Yes,
sorry.
I did want to speak on Mr. Fonda's behalf. I see in the courtroom that there's family, my daughter, my mother, my brother, my niece. I've known Mr. Fonda for 25 years, personally on a level. He lived in the home with me and my mother when my daughter was born. I lived with Mr. Fonda and my mother for years while I was in law school. And you know, I understand the situation, but I could certainly vouch that I personally, as a witness in the case, not as his lawyer, would ask the court to consider exercising discretion in this case, given that I don't see that there's a danger to the community. He's certainly not a flight risk. I would just ask the court to consider hearing testimony from the witnesses that are there and perhaps exercise discretion in this case.
Well, thank you very much, Ms. Chase. I apologize. I didn't understand that you were speaking as a witness.
Judge,
so-
I know it's an interesting situation.
Yes,
but
it
I knew
is.
I was working. If I weren't working here this morning, I'd be in the courtroom with the rest of my family. But I'm here today, so.
All right. Well, I thank you, and I understand your sentiments, but I am going to err on the side of caution and ask that you set an Arthur hearing before the presiding judge.
I understand, Your Honor. Thank you for your time this morning.
Thank you very much.
Your Honor, the only other request I'd make in an abundance of caution, just in order of no victim contact with juvenile whose initials are BG.
Yes, Mr. Fond, I do, as part of my finding, order that you have no indirect or direct contact with the alleged victim in the case. Thank you.
Thank you, Judge.
Okay, that brings us to page 19, Mr. Idris Deval Matthews.
Morning, Judge. How are you?
Good morning, I'm fine, thank you, sir. How are you?
I'm well.
Do you have any arguments regarding the probable cause in this case?
I do not at this time, Your Honor. no.
Okay, I find probable cause in this matter, and then I would turn to Mr. Linder. As to Mr. Matthews, what are
I
your
apologize.
recommendations regarding release or bond?
Well, Your Honor, I want to bring to the court's attention, in defense counsel and I spoke about this matter this morning, Your Honor. Mr. Matthews has 2 open felony cases at the moment, and this arrest would violate his release conditions in those 2 cases.
What are those case numbers?
Judge, I don't see my client. I'm not sure if he's there.
Oh, Mr. Matthews?
Let me check to see which facility.
Idris
he's in.
Deval Matthews on
Thank you.
page 19.
And I apologize to counsel.
No.
I wouldn't
No, it's
proceed.
okay.
Can they hear us at all?
So he knows what's going on.
Oh, I don't know, I have Maine jail. Idris Deval Matthews?
He's definitely in Maine.
Okay.
He's here at Main Jump.
Okay, thank you,
Here he
Ms.
is.
Good morning, Mr. Matthews. I have just found probable cause on count 1, possession of a weapon by a convicted felon. And now I've asked Mr. Linder to make his recommendations regarding bond or release.
And Your Honor, I'd advise the court, and I mentioned I spoke about this matter with counsel this morning already. Mr. Matthews has 2 pending cases, one for possession of cocaine, the other a possession of heroin. This new offense would violate his release conditions.
What are those case numbers and who's the judge?
It's Judge Tim Bailey.
Tim Bailey, yes. Judge
Okay.
Tim Bailey, the possession of cocaine is case number 19-7795 CF10A. The heroin case is 19-9431 CF10A. As far as the new law offense, Your Honor, and I
Is
advise
he on bond on those cases or release?
I
PTR?
have to,
PSO?
He's on
counsel might know
bond.
better than
He's on
me.
bond.
He's on bond, okay.
As far as the new law offense, Your Honor, and I discussed with counsel that I'd be recommending a $10,000 bond in light of the 2 open felony cases.
Judge, and I'd be asking for a $5,000 bond and for the any potential motion for bond revocation to be dealt with in the division with Judge Bailey once I've had an opportunity to speak with my client about the facts surrounding this case.
I'm going to set the bond at $10,000 in this matter and direct that Judge Bailey be, that 197795 and 199431 be placed on Judge Bailey's docket at the earliest convenience regarding the issues surrounding the bond.
That works.
I will advise the assigned assistant state attorney,
Okay.
Your Honor.
Thank you.
Thank you, Judge. Good to see you. Happy holidays, everyone.
Happy holidays, sir. Okay, so that brings us to Susie Gregory. Where's Ms.
Ms. Gregory is in Paul Ryan, Your Honor.
Okay.
Our Spanish interpreter is still here.
Oh, what, do we know, I know there's one that needs a Spanish interpreter that was towards the back.
Main jail, I believe they have.
Okay,
the-
remind me, Mr. Reedy, I'm sorry.
That's good, it's no problem, Judge.
Okay. Good morning, Ms. Susie. You are charged with battery, domestic violence charge. I do find probable cause. What say you, Mr., I believe you were married to the victim, is that correct?
Yes.
Okay, so I do find probable cause. I'm gonna set your bond in the amount of $2,000. I'm gonna order that you have no contact with the victim, Mr. Xavier Antonio Gregory, either direct or indirect. That means if he calls you and wants to talk to you, you could be in violation of my order by talking back. You need to hang up the phone and he needs to go to court in order to get this no contact order lifted. I'm also gonna order that within 10 days you begin an anger management program and that you do not return to the residence without a police escort in order to retrieve your belongings. You're not to go back for any reason by yourself, and that you are on a level 1 monitor during the term of your release. You're only allowed to go to work and go home. You're not allowed to go within 500 feet of Mr. Gregory or his business, okay? Is 2 allowed to work? You know, I go through this every single time. Level 2?
Permitted to work with level 2, but she must give a schedule.
Yes, you are permitted to work, but you must give your schedule on a level 2 monitor. Thank you, ma'am.
Judge, would you consider pretrial release for Miss Gregory? She advises me that she has never been arrested before. She had a job working as a nurse. Unfortunately, she does not have that job any longer. She was living with her husband and her 4-month-old daughter. I understand that she's going to be making arrangements to not have contact with her husband until another judge makes a ruling contrary. And she's been a resident of South Florida her entire life.
That's denied without prejudice to bring that motion up before the judge that's assigned her case.
I'll make those calls for you, Miss Gregory, see what I can do to help you, okay?
That brings us to Juan Hernandez. And I don't know what page he's on, but my review of the probable cause affidavit indicates that he does need a Spanish interpreter. Is the Spanish interpreter here?
Page 20, and he's at the main jail.
Thank you, Ms. Chase. Juan Hernandez. Would you raise your right hand to be sworn, sir? Do you solemnly swear that your translation from English to Spanish and Spanish to English will be true and correct to the best of your ability? So help you God.
I do, Esteban Rojas.
Thank you very much. Would you let Mr. Hernandez know that he is here for his first appearance here?
Señor Hernández, usted está ante este tribunal para su primera comparecencia.
That anything he says will be used against him later on?
Cualquier cosa que usted diga podrá ser utilizado en su contra más adelante.
Okay. Mr. Hernandez, you are charged with failure to stop or remain at an accident site involving non-serious injuries.
Señor Hernández, a usted se le acusa de no permanecer en la escena de un accidente en donde hubo lesiones no amenazantes a la vida,
Operating without a valid driver's license.
así como operar un vehículo automotor sin licencia válida
And giving false information to the police.
y darle información falsa a la policía.
And that I do find probable cause.
Considero que existen indicios probables de delito.
What say you, Mr. Linder?
Señor Linder,
Your Honor, based on the totality of the circumstances,
su señoría, dada la globalidad de las circunstancias,
showing, only thing I see in Broward is an old no valid DL.
lo único que veo en Broward es un cargo viejo por no portar licencia válida.
I'd be requesting a $1,500 bond.
Solicitaría una fianza de $1,500.
Say it again, sir, I'm sorry.
De nuevo,
I'm
señor,
having
disculpe.
trouble hearing because there's so much background noise.
Me cuesta escuchar, hay mucho ruido de fondo.
$1,500, Your Honor.
$1,500, su señoría.
Okay, what say you, Ms. Chase?
Señora Chase,
Judge, I'd like to inquire, I haven't had the opportunity to speak with Mr. Hernandez.
señora juez, yo no he tenido aún la oportunidad de hablar con el señor Hernández.
Okay, how can I help you do that?
Bien, ¿cómo le ayudo?
Just like to ask if he has the ability to post that $1,500.
Okay.
Quisiera simplemente preguntarle al imputado si él tiene la capacidad de cubrir esa fianza de $1,500.
Ahorita necesitaría hacer una llamada, pues.
Well, right now I would have to make a call.
Okay, So how can I help?
Bien, ¿cómo puedo ayudar?
I'm,
Is there an amount that you can afford?
¿Hay algún monto que usted sí pueda pagar?
Pues depende un poco.
Do you have any money in the bank?
Well, it depends. ¿Tiene dinero en el banco?
No, ahorita no tengo. Digo.
No, not right now, I don't.
I would just ask if the court would maybe consider ROR on this.
Le pediría a su señoría que tal vez contemplara la posibilidad de liberarlo bajo palabra.
okay, I will place him on a level 2 monitor pending verification of his address by BSO.
Voy a ponerle un monitor nivel 2 hasta que se verifique su dirección por parte de la comisaría de Broward.
Estaría bien. ¿Sí?
Okay, I take
Su
back the
señoría-
pending verification part. I'll place him on a level 2 monitor.
Si tiene un monitor nivel 2, entonces no es necesario verificar la dirección. Bien, está bien.
Ok. Está
That's
bien.
automatic on the level.
Eso es
Okay.
automático.
And I will
nivel
order
dos.
that he attend 3 12-step meetings per week,
Voy a ordenar que asista a 3 reuniones de alcohólicos anónimos por semana,
that he not have any alcohol while he's on his release,
que no consuma alcohol en absoluto durante su tiempo en libertad condicional.
that he,
Sí.
I don't know, do you have a permanent address,
¿Tiene
Mr.
dirección permanente? No
Hernandez?
sé, ¿usted, el señor Hernández, tiene dirección permanente?
Sí.
Yes.
Okay.
Tengo como 6 años viviendo ahí.
¿Cómo?
Tengo 6 años
I've been
viviendo
living
ahí.
there for 6 years. Bien,
Okay.
gracias.
That he not have any alcohol and that he undergo alcohol testing, urine testing for alcohol
Que se abstenga de consumir alcohol y deberá someterse a
on a random basis.
pruebas de orina sin aviso para detectar la presencia del alcohol.
Okay, and that you
Okay,
have no contact whatsoever with Marnicha Prudent
Y se le prohíbe tener contacto alguno con Marnicha
or
Prudent
Ashton Michael Pierre,
o Ashton Michael Pierre,
either direct or indirect.
ya sea directo o indirecto.
Ok.
Ok.
Thank you.
Gracias.
All right, Ms. Chase, can you see if anyone else needs a Spanish interpreter?
If the interpreter could make an announcement.
¿Alguien más necesita interpretación al español?
We have one more. Page 9,
Página 9.
William Valverde.
Okay,
William Valverde.
give me just a sec. Page 9, William Valverde.
Página 9, William Valverde.
I got it. Okay, so Mr. Valverde, good morning, sir.
Señor Valverde, buenos días, señor.
You have a right to remain silent. Anything you say will be used against you at a later date.
Tiene derecho a guardar silencio. Cualquier cosa que usted diga será utilizado en su contra más adelante.
You are charged with 1 count of domestic battery by
Se
strangulation
le acusa de un cargo de violencia, de lesiones domésticas mediante estrangulamiento.
and a 2nd count of domestic violence battery.
Y hay un segundo cargo de agresión o de lesiones, violencia doméstica.
I do find probable cause.
Considero que existen indicios probables.
What say you, Mr. Linder?
Señor Linder,
Your Honor, I have no information with respect to Mr. Valverde in my database.
su señoría, no tengo información alguna con respecto al señor Valverde en mi base de datos.
Based on the allegations contained in the affidavit,
Dado lo que se aduce en el affidavit,
I'll be requesting an $8,500 bond on one,
voy a solicitar que para el primer cargo se imponga una fianza de $8,500,
a $1,500 bond on two,
$1,500 para el segundo,
an order of no victim contact, Judge.
y que se le ordene no tener contacto con la víctima, señor
Nothing
juez.
further.
Nada más.
Okay, what say you, Ms. Chase?
Bien, señora Chase.
If I can inquire, I'm sorry, I didn't hear what the state, did the state make a
Disculpe,
request?
no escuché lo que dijo la
They want,
fiscalía.
Mr. Linder wants $8,500 bond on count 1 and a $1,500 bond on count 2.
El señor Linder está pidiendo $8,500 de fianza para el primer cargo y $1,500 para el segundo.
If I could just inquire if we would be able to afford that bond?
Si me permite preguntarle al imputado si él puede costear esa fianza.
Answer out loud.
Tiene que contestar en voz alta. No.
Okay.
Are you employed?
¿Tiene empleo usted?
Speak up, please.
Yes. Tiene que hablar.
Do you have any money in the
Yes.
bank?
¿Tiene dinero en el banco? No.
I'm sorry, 1 second. And you, one at a time, okay? All right, no money in the bank?
¿No tiene dinero en el banco? No.
Do you own or rent a home?
¿Es propietario de o alquila una vivienda?
Sí, alquilo.
Yes, I rent.
Okay, and how much is your rent?
¿Y cuánto es su alquiler?
1,200.
1,200.
Okay, and how much do you make a month?
Bien, ¿y cuánto gana por mes?
720 por semana.
$720 a week.
And do you have children that you support?
¿Tiene hijos que usted mantiene?
Sí,
Yes.
How many?
¿Cuántos?
uno.
One.
Okay. And do you live with the alleged victim in this case?
¿Vive usted con la supuesta víctima en este caso?
Sí.
Do you have
Yes.
a place to stay away from the alleged victim?
¿Tiene dónde hospedarse que no sea con la víctima?
No por ahora, pero puedo buscar.
Not for now, but I can find someplace.
Okay. Judge, I ask the court to consider reducing that request to maybe $1,500 per count.
Señora juez, voy a solicitar que se reduzca esa fianza tal vez a 1,500 por cargo.
Okay, I will set your bond in the amounts of $1,500 on each count, but I
Bien.
will place you on a level 2 monitor.
Voy a fijar su fianza en el monto de $1,500 para cada cargo, pero sí le voy a imponer un monitor nivel 2.
You are to, within 10 days,
Debe, dentro del plazo de 10 días,
enroll in an anger management class.
matricularse en un curso de control de la ira.
You are to have no contact whatsoever
Deberá abstenerse de contacto
Fernandez,
alguno con Marjorie Fernández.
and you are not to go within 500 feet of 1225 South Dixie Highway West, apartment 206.
Y no deberá acercarse a más de 500 pies de la 1225 South Dixie Highway,
Pompano Beach, Florida,
Pompano Beach,
33060.
apartamento 26,
If you, ha-
3360.
if you have belongings at the home, you are to get a police escort in
Si
order
usted-
to retrieve your belongings.
Si tiene pertenencias en la casa o el apartamento, deberá ir con escolta policial para retirarlas.
You are only allowed to leave your home to go to work.
Solo
and
se le
come back.
permitirá salir de su casa para ir ida y vuelta a su trabajo.
You have to provide a schedule to BSO for your work schedule
Deberá entregarle una agenda de trabajo a el BSO
and let them know when you go to retrieve your belongings.
y hacerles a ellos saber cuando usted va a ir a retirar sus efectos personales. Su
Yes.
señoría pregunta.
I heard the court say he needs to stay 500 feet away from that particular address.
Sé que su señoría dijo que él debe mantenerse alejado a 500 pies de esa dirección.
We are processing these Elmos where the victim vacates the residence and then the defendant can return.
En
I
este,
put 500 from the victim at all times.
Yes.
dado el caso de
Yes.
que la víctima desalojara el apartamento y luego el imputado pudiera regresar, mejor será decir que se mantenga a 500 pies de distancia de la víctima.
And
Sí.
obviously, the only time he's allowed to go there is when he goes with the police escort to get his belongings.
Y evidentemente el único momento en el que se le permitirá ir al domicilio será cuando vaya con escolta policial para retirar sus pertenencias.
Do you understand, Mr. Valverde?
¿Entiende, señor Valverde?
With the
I
victim.
understand that, but I am her support. So my daughter is with her too.
Understood. Understand you cannot have any contact.
Entienda que no puede tener ningún contacto.
Sí, ya, lo entiendo.
Yes, I understand.
Okay, thank you very much.
Bien, muchas gracias.
Madeline Nicole Snyder,
Is that all for the Spanish cases, Your Honor?
you want to make sure, Mr. Court Reporter?
At the main jail, I
Court
think
interpreter.
already. I don't know if the other.
Nobody's told me anything about any of the satellite courthouses,
Okay.
satellite jails needing a Spanish interpreter, Judge.
Okay.
Thank you, you're excused, I appreciate it, sir. That brings us to Ms. Snyder. I believe someone's here to speak up for Ms. Snyder. Good morning, Ms. Snyder. You are charged with touch or strike, battery, a domestic violence charge. I do find probable cause. Good morning, ma'am. Would you please state your name?
Good morning, I'm Dr. Michelle Cipriani.
I'm sorry, I can't hear you. Would somebody turn off their mic for a second? Thank you.
Judge, she's the victim.
Okay.
I'm also her mother.
Yes, I read the police report. And state your name again, please, ma'am.
Dr. Michelle Cipriani.
Good morning, Ms.
Good morning.
Cipriani. Nice to see you. And you, sir?
Scott Snyder, father.
Good morning, Mr. Snyder. Okay, so what do you want to say, Ms. Cipriani?
I want to say that my daughter is a victim. I am not a victim. My daughter has been under duress since many, many years, but since 2016, my husband and I were separated. We've been recently divorced. We also recently are trying to bring our family back together. Madeline was also a victim during the Parkland shooting, where she was in the room with what happened. She saw everything. She has been having a lot of emotional problems. She's been having trouble with relationships with her boyfriend, with her sister, with her dad, with me, with everyone. I flew her two sisters here from Colorado, flew them to me. I live in Georgia, I live in Atlanta, and we flew here to try to have a Christmas with our child, to try to bring our family together. Yesterday, she got into a small verbal altercation with her sister. Her twin sister ran out of the house. We stepped out of the bedroom where we were sitting. He was working from home yesterday. We got into an altercation where he was between she and I. We were trying to restrain her because she wanted to leave, and we didn't feel that she was emotionally stable to drive. We didn't feel that she was safe to be out of the home. We wanted to try to talk to her. So we tried to restrain her, and that turned into an altercation. Initially, she got upset. She called the police. She wanted me removed from the house, but she changed her mind. The police came anyway, and rightly so. And when they did come, we explained to them the situation. However, because during the altercation, her arms were flailing, she didn't try to hurt me, and I am not hurt. I'm her mom. I'm here to help her. And as a physician, I know what she needs, but as a mother, it's difficult to convey that to a child. And it's difficult for someone who doesn't recognize or want help immediately. And she feels as though we're ganging up on her, and really we're trying to help her. And I ask for mercy for her. I ask for help for her. And I ask for help for her family.
Yes, ma'am. Thank you. Mr. Snyder, do you have anything to say, sir?
Madeline she's a great kid, but she is having troubles dealing with these emotions, the anger, and it's escalated quite a bit since the Parkland incident. And we just want her to get the help that she needs.
Mr. Linder? Mr. Linder, do you have any recommendations regarding this case?
Your Honor, Ms. Davidson is handling on this.
Oh, okay. Ms. Davidson?
Hi, Kesha
Hi.
Davidson for the state, Your Honor.
Good morning, ma'am.
The state will be asking for a $1,000 bond, Your Honor. I've spoken to the mother in this case. She's only here for a couple more days, staying at the residence. Because of that, the state would not be objecting to not imposing a no victim contact at this time. And after speaking to the mom, we'll also be requesting a mental health evaluation, Your Honor, any possible follow-up treatment.
Okay, I will set the bond at $1,000, and as a condition of your release, ma'am, you are to at least enroll in an anger management class, obtain a mental health evaluation, and any follow-up treatment recommended. Can you do that, Ms. Snyder? I gotta turn your mic on.
Yes, Your Honor.
Okay, all right. This completes the hearing. Thank you, ma'am. Thank you both.
You're good, so they're gonna post a $100 bond.
Jasmine Simone Pierce. Good morning, Ms. Pierce. You are charged with touch or strike battery dating violence. I do find probable cause. What say you, Ms. Chase?
Judge, it's my understanding that she has no prior record. She does have a place to live separate and apart from the alleged victim in this case. She would be living with friends. She works full-time at a restaurant, but does not have any money in the bank. In consideration of this, we were gonna ask the court for pretrial release.
Okay, I will place you on pretrial release. However, that will be on a level 2 monitor. You're only to go to work and to whatever meetings you might go to, because I'm going to order that you at least commence within 10 days an anger management program, and that you have no contact whatsoever with, I think this is a cross arrest, isn't it?
Yes, Your Honor. Brian
It
Clark.
is, Judge, yes.
With Brian Clark.
Yes, Your Honor.
That means direct or indirect contact with Brian Clark, and that you, if you have any things at a property he's living at, it doesn't list an address for him, but you're not allowed to go back to that property unless you have a police escort. If he has some of your stuff, you're not to go back there without a police escort, okay? Thank you.
Judge, there are some cases that the main jail requested be called out of turn.
Sure. Which cases are those, Mr. Reedy?
On page 8, we have Mr. Brown.
Not finding.
Adrian Brown.
Here, Adrian Brown? I don't
Yes,
have
Judge.
a,
Yes, Judge.
okay.
Also
Adrian
on-
Brown, good morning, Mr. Brown. You are charged with, how are you, sir? You're charged with domestic battery, and I do find probable cause. What say you, Ms. Chase?
Judge, currently he's unemployed, may be able to reside with his grandmother. He doesn't have any money in the bank or savings. I'd ask the court to consider that when setting a nominal bond.
Mr. Linder? Oh, okay. I know I can. That's the nice way of saying, give me back my papers.
When I given Kesha Davidson for the state, given Miss,
I'm listening.
given Mr. Brown's criminal history as recently as 2018, he was sentenced to a year and 3 months for battery on a detention facility officer. He was released in June of 2019. The state will be asking for a $3,000 bond, Your Honor, plus level 2 GPS.
I will set your bond in the amount of $1,000 and order that you be placed on a level 2 monitor. That means you can only go to work or be at home, and that you have no contact whatsoever with Mr. Jermaine Hugh Brown, that you not go within 500 feet of 7504 Northwest 33rd Street, Lauderhill, Florida 33319, as long as he's living there, that the only way you can go back there is with a police escort to retrieve your belongings, and that you begin an anger management class within 10 days of your release. Thank you. What is the other one, Mr. Reedy?
On page 12, Jermaine Fudge.
I'm gonna request a photo order on Mr. Fudge.
Granted.
Jeremy?
Here we go. Okay, so Mr. Fudge, you are charged with disorderly intoxication in a public place and resisting an officer without violence. I do find probable cause. What say you, Ms. Chase?
Judge, first I'm gonna request a photo order. to take
I've already
photographs.
granted that. Yes,
Okay,
ma'am.
I'm sorry, I didn't
It's
hear
okay.
that. Basically, at this point, he does not have any money in the bank. His employment is working temporary odd jobs, with an unstable income. I believe there are no significant priors. I was gonna ask the court for ROR on this misdemeanor.
Mr. Linder?
He's out on tampering with a witness or victim and domestic violence battery, Your Honor.
And what's the case number on that?
19-14769 CF10A.
What judge is that?
Judge Allspector.
And is he on some sort of release on that matter?
He is, Your Honor. What I'm showing is that he posted a, when it was an up file from a misdemeanor, Your Honor, while it was still just a battery, he posted a $1,000 bond. At a later date, the state filed the information and added the felony charge.
Okay, so that's a warrant currently?
No, well, let me check the felony matter. No, as far as I can see, it is, court date notice was sent out. He's scheduled for arraignment January 16th before Judge Allspector.
Did you know that, Mr. Fudge, that you have a court date?
I do know, Your Honor.
You did not know you had a court date?
No, I did not.
When did the notice go out?
I appeared to court previously the day after my release from the previous case. I appeared to court and I presumed that everything had been resolved at that point.
Okay, so you thought because you had been released, the case was over?
And I did appear to court after my release. I already appeared to court.
Okay, so I am gonna place you on a level 2 monitor. And I am going to order that you only go to work or go home, and that you have no contact with,
I'm homeless.
Okay, well, you apparently had a friend, and that friend was allowing you to stay with them, according to the probable cause affidavit.
And Your Honor?
What's the name of the person at whose home he was found?
I'll check, but Your Honor, if I could just update Your Honor. The reason he hadn't gotten court date notice yet is it was just sent out, I believe, the other day.
Okay.
And it was actually, but he needs to be aware, the address the clerk's office has is this address.
That's why he's going on a level 2
No,
monitor.
I'm just letting you know, the court date notice, they're going to this
Okay.
4117 Southwest 14th Street address.
And he's listed an Alabama Avenue address as his
Yeah, I'm
home.
just, based on the report from the pending case, the address they had, the clerk's office had on the reports was the 42nd Avenue, 14th Street address, I apologize.
Okay, so you are on a level 2 monitor, you're allowed to go to work and home, you're to have no alcohol during the time that you're on release, and you're to attend at least 3 12-step meetings a week. And you're not to go back to the address that you were arrested at, sir, under any circumstances until further order of the court. And that address is 1450 Southwest 42nd Avenue, Fort Lauderdale, Florida, 33317. Is there anything further?
Judge, I just asked the court to consider leaving the no contact order in place on the domestic violence case. Putting him on level 2 on the misdemeanor in this case, at this point, he's homeless. He is not going to be living with the alleged victim. The address the court mentioned is his father's, where he can get mail. But at this point, that's basically putting him on a no bond hold.
Okay, your objection is noted. Thank you, counsel. He's on a level 2 monitor. He's not allowed to go back to the address he was arrested at. He's to attend 3 12-step meetings per week. I think that's all I said, correct? And no return to the address? Okay. Omarion Watson. This one, yes, this one I have only warrants. I don't have any PCs. Okay. Thank you very much.
Just to let you know, I provided a copy to Mr. Reedy.
Okay.
All you have is the original juvenile pickup arrest warrant affidavit.
Yes, sir.
And also there is a lab report attached at the end.
Okay. Good morning, Mr. Watson. You are charged with burglary with a battery or assault, attempted felony murder, aggravated battery with a deadly weapon, and grand theft auto.
Your Honor?
Yes, sir.
If I could inquire, on your findings, I believe it should have the case number
For the juvenile case?
well, no, the new adult case, the direct file case. On the findings sheet prepared by the clerk.
I have 19-14997 CF10A.
On count 3, does yours say 1499?
No, sir.
Okay, it's on the booking, so I wasn't sure. Just,
Not so far. I don't see any that say 1499. Mr. Reedy, do you have any arguments regarding the probable cause in this case?
You have one moment, Judge.
Certainly.
Mr. Watson?
Yes, sir?
Possible identification issue.
I believe Mr. Linder indicated there was a lab report.
Your Honor, I would note, in the affidavit, they mentioned that there were latent fingerprints taken from the car, which matched Mr. Watson. It also makes a reference to blood left behind in the car. They got the results of from the lab after the warrant was issued. That's why I attached the lab results dealing specifically with the blood that was collected, matching it to Mr. Watson's. And I would note the blood was taken from the interior of the vehicle.
I do find probable cause as to all counts.
Your Honor, just one thing I would want to note, it's not mentioned on the findings, but just for the record, and I'm looking at the information right now, count 1 was actually charged with burglary of a dwelling with a battery while armed. So I guess in the alternative, it would be a PBL in either situation. Based on the evidence contained in the affidavit and the lab results, Your Honor, the state would be seeking a finding of proof evident or presumption great on both counts 1 and 2. They are both punishable by life offenses. And I'm sorry.
Go ahead.
This would obviously be for first appearance purposes only.
Yes. Without prejudice to the defense to.
Yes, and then that would be over our objection at this stage of the proceedings, Judge.
Okay, well, at this juncture, I do find proof evident presumption great on counts 1, 2, and 3, and set the bond on count 4, grand theft auto, at $1,000, without prejudice to the defense to raise these issues again before the filing judge. And I would just ask that the public defender note that the direct file unit needs to be notified regarding Mr. Watson.
And Your Honor, he is entitled to a bond on count 3. Whatever bond Your Honor deems appropriate, the state would be satisfied with.
Okay, I will set the bond at $15,000 on count 3. Thank you very much, Mr. Watson. Anna K. Anita Armstrong.
This is mine.
Judge, I think we still had 2 more that the jail wanted to call.
I thought, I'm sorry.
Right
Let's
after
go.
Mr.
I'm sorry.
Watson would be
We-
Mr.
Condon?
Condon.
Okay. Jesus Gabriel Condon. Good morning, Mr. Condon. You're charged with expired tag, which is not for magistrates, disobeying a traffic device, which is not for magistrate, violation of your community control, and violation of your community control on 2 counts in case number 1814186 CF10A. I do find probable cause. You're set to go before your judge on Thursday morning at 8:30. Thank you, sir.
Excuse me, I have a question, ma'am. You said there's 2 counts? I'm only on community control for 1 count.
You have 1 case with 2 counts. It's 2 counts in 1814186 CF10A.
Your Honor, just so he's aware, what the officer did was, he charged him 1 count on the warrant that was signed.
Okay.
And the other count on a 94806 warrantless arrest.
Okay,
But
so
since
you're
there's a
right,
warrant-
it is just 1 count. It's technically 1 count. Sorry, sir. And then page 23, Roberto Almi. Is he off medical leave? Okay.
He is back. Your
There we are. Good morning, Mr. Almi. Yesterday on December, how are you, sir? Yes, good. Yesterday, Judge Carpenter Toy did find probable cause on battery for the charge of battery on an officer. I am here to determine your release. What say you, Mr. Linder?
One moment, Your Honor. I'm showing. Your Honor, if I could just have a moment, if Ms. Chase wants to proceed, obviously, I know.
Ms. Chase, what say you?
Judge, first I'm requesting a photo order for injuries. Second thing, I can comment that he currently is residing with his parents and brother, currently unemployed and does not have any funds or money in the bank at this point. It would be up to his family in hopes that they would help bond him out. It's my understanding, although I had not had a review of the probable cause affidavit, that there was a mental health crisis at the time, seeking a potential Baker Act. I'd ask the court to consider that and setting an appropriate bond.
Okay, thank you very much, Ms. Chase.
And that's what I wanted to look up, Your Honor. I share Ms. Chase's concerns that there are mental health issues here. Mr. Almy was arrested. Well, first you can see he was arrested December 18th, and then a week later. He was arrested about 2 weeks, 2 weeks prior to this on the 5th for criminal mischief at a church. He had a $1,000 bond that he posted, but reviewing the allegations in that case, in this case, I do have concerns, Your Honor. What I would request is,
What happened to that case?
it's still pending. A final
Where is
decision has
it?
been made. He's
Okay.
out on a $1,000 bond. What I would request is, whatever release conditions the court deems appropriate, whether it be bond or non-monetary, if he is going to be supervised by pretrial, I would ask that there be a mental health evaluation.
Absolutely. Okay, what about, has anybody had any contact with his family where he would be, what's going on with them and whether or not it's okay for him to go there? So, Ms. Chase, I'm
Yes,
gonna.
he has not been able to use the phone and make contact
Okay,
with them
can
at this
somebody,
time.
can you possibly make a call? If he's got a phone number, I'd like to have some contact with the family and see what their response is. So I can put him on a brief recall so that someone can contact his family and see if they're amenable for him, to him living at home and what kind of resources they have and whether we can help them.
Okay, thank you.
Thank you. We'll be back with you, Mr. Almy. Yeah, at noon. Is it noon yet? No, just call. Okay, will do. Okay. All right, Anna Armstrong. Okay, good morning, Ms. Armstrong. You're charged with aggravated assault with a deadly weapon. I do find probable cause. What say you, Ms. Chase?
Just as my understanding, she does not have a prior history or record. She's currently not working. She's unemployed, living with her grandmother. It's my understanding this is not the alleged victim, so she would be able to reside away from the alleged victim. I'd ask the court to keep that in mind in setting a reasonable bond. We were looking to ask for a standard pretrial, but in the alternative, if we could look into a monetary bond within reason.
Mr. Linder?
Thank you, Your Honor. It is true. I see no history. That being said, I'm requesting a $2,500 bond and no victim contact based on the level of violence allegedly using a knife.
Okay.
Judge, if we could reduce that to $1,500.
Ms. Armstrong, I will set your bond at $1,500. I'll place you on a level 2 monitor. You are not to have any contact whatsoever with the victim, Mr. Isaiah Tucker. If he has any of your stuff, you're to get a police escort and obtain it. You're not to call him regarding anything or have anybody else call on your behalf. You're to commence an anger management program within 10 days of your release. You're not to go within 500 feet of Mr. Tucker's home. Thank you very much. Elmine Augustin, I have no page 2 on the probable cause affidavit for this person. I have page 1.
Here, if you like, if I may approach, Your Honor, I believe.
Judge bonded?
Oh, bonded. Never mind. Thank you, that's right. That is right. Okay, Diana Marie Culbertson.
We leave at North Broward?
North
Okay.
Broward, Judge.
Thank you, sir.
Morning, Your Honor.
Let me find you, Mr. Culbertson.
Miss.
Ms. Culbertson, I'm sorry.
Good morning, ma'am. Merry Christmas.
Merry Christmas to you, too. I can't get the... Give me a sec.
No problem.
This thing won't take me back to my jails. It's kind of stuck. I need to see. Nobody's helping. All right, maybe. Okay, hang on. Here we go. North Broward. There you are. Good morning. How are you, Ms. Culbertson? Okay, Ms. Culbertson, you are charged with misdemeanor battery. I do find probable cause. What say you, Mr. Reedy?
Judge, in speaking with Ms. Culbertson, she grew up here in Florida. She does have a friend whose phone number she has provided me with who might be able to post some sort of a bond for her. She is currently unemployed, unfortunately. She does have some medical issues that have prevented her from working, so she has not been able to save any money. Therefore, she's really not able to afford any kind of a monetary bond. I'd ask the court to consider pretrial release for Ms. Cuthbertson with the condition of no alcohol, as it appears that the incident here.
I saw that, Mr. Reedy.
Yes.
What say you, Mr. Linder?
Your Honor, the problem is that and the problem is, Your Honor, she's on pretrial after she was taken into custody for violating pretrial, where she failed to report to pretrial release services. They had no idea where she was. And then Judge Culver signed a warrant taking her into custody and then released her again to pretrial.
And the underlying case was before Judge Culver, or he was the magistrate?
Oh, no, it's his case. The warrant was
It's his
taken
case?
ahead.
What is his case number?
198908 CF10A. One count of possession of heroin, one count of possession of marijuana under 20 grams.
Mr. Reedy, we might want a picture of Ms. Culbertson. Okay, I do find probable cause to revoke the bond based on this new arrest in case 198908 CF10A, and I will set the bond in this case at $1,000 and strongly advise Ms. Culbertson to try to take advantage of any 12-step opportunities you have while you're in jail.
Judge, we're going to ask for a photo order from Ms. Culbertson
Granted.
as well.
Your Honor, Judge State would request no victim contact on the battery.
That's correct, Ms. Culbertson, you're to have no contact whatsoever with Giuseppe Vittorio Latona.
Not a problem. I don't even know who that is.
Don't
Okay,
say anything about
let's
your
keep
case,
it
Ms.
that way.
Culbertson.
Is she to be held no bond on revocation?
Yes. but I would like her to go before Judge Colra as soon as
And
possible.
I will, let them know. No, the revocation also. She came. Thank you.
That takes us to Vanessa Daly. Is she
No
in
problem, Your Honor.
North Broward? Okay, good morning, Vanessa Daly. You're charged with failing to appear for a misdemeanor, for a municipal ordinance violation. Good morning.
Good morning, Judge Benson, good to see you again.
What say
All
you?
right.
Is the state on this one?
It's a city case, Your Honor. I'm here
Okay.
on behalf of Mr. Shate's office. We've already
Okay.
been appointed. She was a medical reset.
Okay, what can we do for Ms. Daly?
Well, Judge, this is the only case that I see is holding her unless the.
Okay, I would
something
withhold
else.
adjudication and sentence her, and, based on the time she spent in jail, which is since December 22nd.
Yes.
Take judicial notice of that time.
Would you like
and
to
waive
resolve
any
your
court
case?
fines or fees unless someone has an objection to that.
I don't think anyone here would.
Okay, so Ms. Daly, you wanna do that? I'll take judicial notice of the time you've been in, cause you've been in since, since yesterday, and withhold adjudication, which means you won't have a conviction for this offense.
Okay.
Okay?
Okay.
All right, now, do you know we have community court? Why don't you come down to City Hall on January 8th? We might be able to help you with some services. Just walk on in, and there's all kind of help. So can you come and see us on the 8th of January, just on your own? Nobody's gonna make you do it.
Just
But-
come.
8th of January.
Yes, ma'am.
City
January.
Hall.
Yes, ma'am. Fort Lauderdale City Hall. Will you come down and we'll see if we can help you?
Okay, so I'll be free when?
Today.
Today?
Yes.
Yes.
Praise the Lord.
Yes.
I'm talking about two different things. I'm sorry, I talked too fast. I'm gonna resolve your case so you get out today, but I want you on your own on January 8th to come to Fort Lauderdale City Hall so we can try to get you some.
Okay, baby.
Okay.
All right. God bless you.
All right, take care.
Have a good day, Vanessa.
All right.
Merry Christmas.
Melquinice Macklin? Melquinice Macklin. Nobody,
I'll check to see what facility she's at, Judge.
is she with you, Ms. Chase, Melquinice Macklin?
She should be at Paul Ryan.
Paul Ryan.
She is.
Paul Ryan. Okay, thank you, Deputy. Do you have Melquinice Macklin?
She's in court.
Your Honor, and Mr. Reedy, I don't know if you have an objection. This is a technical change of charge from one type of aggravated battery to another.
Okay.
She has a no bond hold on one count and $100,000 bonds in other counts. Bond was originally set at $10,000. I was just going to be asking the court to reset the bond at $10,000.
Okay, so without objection from the defense, the court will set the bond on aggravated battery with a deadly weapon at $10,000 on case number 19-13827 CF10A. Mark Porter. Ms. Chase, do you have Mr. Porter? Anybody?
Confusion in terms of Porter, which Porter?
Mark Anthony Porter.
That's you, right? Okay.
Okay, good morning, Mr. Porter. You have an out-of-state hold on a felony warrant, and I do find probable cause, and your bond is set at no bond. You'll be going to extradition. Okay? Thank you, sir.
Thank you.
Nicholas Jaramello? Do you have Mr. Jaramello, Ms. Chase?
Reset for the afternoon, Judge.
Well, are you here for Mr. Jaramello? He's gonna be here at 1:30. Okay, is that correct? I didn't know we had an afternoon docket. Am I the afternoon docket? Okay.
So we reset them on the channel to address both. But if you write in touch.
Okay, I'm happy to do, well, he's not here. They have to pull him. Ms. Chase, can you have them pull Mr. Jaramillo?
They can pull him, he's on the second.
He's on the second floor?
Right, let me find out, Judge.
Okay.
It's easier to do that than to have them come.
Yes, I don't want them to have to wait for 3 hours. Just give us a second, and we'll try to get him up here. Brian Clark? Who, Ms. Clark, Ms. Chase, are you able to contact the deputies to?
I just asked regarding Mr.
Okay.
Jaramillo, I just asked if they can get him.
Great, thank you
No.
so much. All right, so we're here on Brian Keith Clark. He's charged with touch or strike battery. And someone's here on his behalf. Good morning, sir. Your name, please?
My understanding they just took Mr. Clark out.
What?
If we
Okay.
could,
Sure.
I don't know, he's not in the room right at the moment. I did speak to him earlier, but I'm working on it, Judge.
He's got someone here on his behalf, Ms. Chase. So, sir, if you'll just have a
Understood.
seat, Ms. Chase is over there by herself. She's trying to get everything together. Okay. Okay. Anthony Lamar Williams? Well, yes, we did, because for some reason they took him out of the.
Judge, they're going to get Mr. Clark now.
Okay. Mr. Williams, you're charged with domestic violence battery. I do find probable cause. What say you, Ms. Chase?
Can you ask for standing, please?
Alright. Judge, at this point, he's currently unemployed. I'm sorry, Judge, I apologize, I misread my notes. He's employed as a cook, but does not have, he makes $250 a week. Alright, so Judge, he makes $600 every 2 weeks. At this point, he can live with his mother, which would be separate and apart from the alleged victim. I believe there's a minimal prior history. We were gonna ask for standard pretrial.
Okay, Mr. Linder?
Your Honor, Kevin Davis for the state.
I'm sorry, I keep referring, I'm so sorry.
That's okay, Your Honor. Your Honor, given the facts alleged in the PC, the fact that he was so persistent, children were present at the time, Your Honor, and given his criminal history, the state will be asking for $2,000 bond.
$2,000 bond? $3,000 bond. Okay, Mr. Williams, I am going to set your bond at $3,000. I'm going to place you on a level 2 monitor. You're only allowed to go to work and go home. You're not to have any contact whatsoever with Anna Doris Williams or the children who were present without further order of the court. You're not to come within 500 feet of 2327 Washington Street, 3C, Hollywood, Florida, 33020, as long as Anna Doris Williams or any of the minor children are living there. You are allowed to get a police escort to go there to collect your belongings. That's the only reason you can go there. You are to start a anger management class within the next 10 days and a parenting class within the next 10 days. Thank you very much.
Judge, it's my understanding he doesn't have children in terms of the parenting classes. Why are we requiring that?
My understanding of the PC is that there were children present at the time.
I don't.
He has, they might not be his biological children, but they're his children by marriage. It's the child that called the police.
All right, thank you for the clarification.
Yes, ma'am. Don, do we have Mr. Clark here yet, Ms. Chase?
Yes, Judge, he's present.
Okay, come on up, Mr. Clark. Mr. Clark is charged with touch or strike battery, dating violence. I do find probable cause. Would you state your name, please, sir?
James Jones from Adamville.
Okay, and what is it you'd like to make the court aware of, sir?
The family did refer me, but I just heard, I guess he had a cross arrest.
Yes.
So I know they're limited on funds, so if he could get pretrial, if not, I know they can afford like $1,000 bond.
Okay, thank you very much, sir. What say you, Ms. Chase?
Judge, that was what I was, at this point, I know that, Mr. Clark does not have any money in the bank or funds. He would be relying on family or someone else to bond him out, so he doesn't have any means to do so himself.
Okay, what say you, Mr. Linder, or Mr. Linder's associate? Ms. Davison?
$1,000 bond will be paid.
I'm sorry, I'm having trouble hearing. Ms. Chase, could you turn off your microphone?
Your Honor, the state will be asking for $1,000 bond, the same special conditions that were given to the cross arrestee, Ms. Pierce, which is anger management classes within 10 days and level 2 GPS.
I will set your bond at $1,000 in order that you be placed on a level 2 GPS monitor, that you only leave your home to go to work. You are to stay away and have no contact whatsoever with Jasmine Simone Pierce. If you do live with Ms. Pierce or you have belongings with Ms. Pierce, you have to get a police escort in order to retrieve those belongings. You are to begin an anger management class within 10 days of your arrest. And I believe that's it, correct? All right, thank you, Mr. Clark.
You can recall Mr. Almy if you wish, Judge.
Thank you, sir. Mr. Almy, right? Roberto Almy? Okay. Ms. Chase, if you could get Mr. Almy to come back up.
Yes, sir, Judge.
Mr. Reedy, were you able to find out anything from the family?
I did speak with Mr. Almy's mother. There was a bit of a language barrier, but I did get a very clear message from her that Roberto does have some issues, as we've discussed prior. She's concerned about that. I think she kind of likes the idea of a mental health evaluation being ordered for Mr. Almy, and he is welcome to stay in her house.
Okay. And Mr. Linder or Ms. Davis, did you indicate that there's no prior issues with the family, correct?
None of that.
Okay. So I will place Mr. Almy on a level 2 monitor. I will order that within 10 days of his release, he obtain a mental health evaluation and any follow-up treatment. I think Mr. Almy's family is going to need some help with that. Is there an agency that we can contact to get them involved in the
Judge, it's my understanding he's with Henderson Behavioral Health.
Okay, great.
They give me therapy, they give me everything.
That's
So
great.
you can
So
probably
if,
arrange it through there.
yes, you have to go back and see them, all right, Mr. Almy? And you need to do whatever they tell you to do,
No
okay?
problem, I'm willing to
Great.
do everything.
Okay. What is the name of your counselor, Mr. Almy?
My counselor, I have a case manager.
What is your case manager's name? I'm sorry, I said the
His
name
name
wrong.
His name is Abdul, but I haven't seen him in a while.
Well, what, do you know,
I don't know if the case is still active.
Okay.
But I do have another case manager. If they call them on Henderson Behavioral Health and Donan Johnston.
Oh, that's good. We got a first and last name. What's his first name?
No, I don't know his name.
You said
I'm
Dornan.
saying
Who's Dornan Johnston?
No, that's what Behavioral Health and Johnson. That's what the address of the Behavioral Health is.
Okay. Can somebody contact Mr. Johnston or Abdul and let them know that we need to get services and we need to get this case active? You have to, Mr. Almy, you have to go. Before you had to go because it was helpful to you. Now you have to go because I'm ordering you to go to Henderson. If you do not go to... Okay, I'm just making...
I'm willing
Okay,
to do everything.
all right, let me finish. If you do not do that, then you get revoked and you go back to jail. So you have to go or else you go back to jail. Do you understand, sir? Okay.
Okay, I will go.
All right. Thank you, Mr. Almy. Mr. Reedy, can you be kind enough to make another phone call and let them know he's gonna get out today? Well, wait a minute, did I order that he be with you?
Yes, ma'am.
Okay, so you'll let the,
Well, you did say a GPS monitor, correct?
level 2,
So it may not be today.
okay,
I can almost guarantee you it will not be today.
okay,
But tomorrow's another.
that's right.
So probably
I'm concerned with all these arrests that he needs to be on a monitor.
Clerk, please don't split the pretrial orders that are coming your way. No worries.
Thank you, Mr. Almy.
Judge, I'm sorry, I'm just a little concerned with the ankle monitor. I'm looking at
Please,
Mr.
madam.
Almy.
I
He's
know.
got wounds on both of his ankles and they're bandaged and they need wound
From
care.
shackles
I'm
and
putting a
TGK.
monitor on, might be problematic, 'cause
Well, I'm sure that if there's a problem, BSO will let the judge know and he can go back before the judge for that.
all right.
Do you
Yeah.
want photographs taken of Mr. Almy?
I think I requested that previously,
Okay.
yes, Judge, yes.
You
Thank
might wanna make sure they know the ankles is the issue.
Okay, well, all right, thank you.
I'm sorry, Mr. Almy, but you have a pattern of having contact with the police that ends up there in the chair, and I wanna keep you out of trouble. Okay? That takes us to Don Wee. Good morning, ma'am, come on up. And, oh, have we found Mr. Jeremio?
Judge, we have Mr. Moy.
Okay, can you double check on Mr. Jeremio?
I believe he's here.
Okay, great.
Jeremio's here, yes.
Okay, good, great. Good morning, Mr. Mui. You are charged with touch or strike battery domestic violence. I do find probable cause. Good morning, ma'am. And would you state your name in relationship to Mr. Mui?
Your Honor, my name is Yuha Mui, and I'm the wife of the.
Okay, Ms. Chase, could you turn off your mic, please? Thank you. Okay, so you are the wife and victim in this matter. What do you want to let the court know, ma'am?
Basically, our family go through a lot of stress lately, and my daughter is in the process of applying for college, and January 1st was the deadline. And we have some visitor coming, and then suddenly she changed her mind. She doesn't want to apply anymore. So I'm kind of like argue with her, and we kind of argued with each other, me and my daughter. And then she started crying, and then hard. And then so that's why my husband, I think, is just basically carrying my daughter, doesn't want her to cry anymore. So that's why she kind of was trying to stop the argument and then push me a little bit. And then at that time I called the 911, but I kind of regret and hang up the phone. But then at that point it was too late.
Right. Yeah. Okay, thank you. Ms.
So,
Davis?
Your Honor, at this time, the state will be asking for $1,000 bond because Mr. Moon doesn't have any criminal history and will also be asking for no victim.
Actually, I do think he is a loving father and also a gentle person.
Well,
so hope
I'm sorry,
you
ma'am, but
guys-
he's not gonna have contact with you until he enters and completes an anger management program and he goes before another judge. That's not without prejudice to you to raise those issues before another judge, but I am not going to allow contact. Ms. Chase?
Is he permitted contact with his daughter,
He
Judge,
can,
just for clarification?
he can have
Okay.
contact with his daughter, but not with the victim in the matter. He's not to go within 500 feet of the house as long as she's living there, unless he's gonna get a police escort. I will set the bond at $1,000. I will place him on pretrial release with the following special conditions. That
Judge,
he
I'm sorry, I
have
didn't hear the bond.
$1,000.
Okay, thank you.
No contact with the victim. He can get a police escort in order to retrieve his belongings from the home. And he's to begin an anger management class within 10 days of his release.
Okay, thank
This
you,
is
Your
without prejudice to you, Ms. Mui. He's gonna go, his case will be filed before a judge, and you can go back before that judge and make the same request, I understand. But not, and you're not allowed to call him and contact him because then he is in violation of the no contact order,
But is that
okay?
possible? I can go through another person and then call him.
You cannot use a second or third, well, he cannot contact you.
Right.
I have no jurisdiction over you to tell you what to do.
Okay.
But he cannot have contact with you, okay?
Okay.
All right?
Thank you, Honor.
Thank you very much. That brings us to Robert Herzog. Yes?
We can call Jaramillo if you're on.
Oh, that's right. Great. Come on up, Miss. We're here on Nicholas Jaramello. Good morning, Mr. Jaramello. You are charged with touch or strike battery, domestic violence. I do find probable cause. Would you please let me know your names, ma'am?
My name is John Jaramillo, I'm the father.
I'm sorry, Ms. Chase. Thank you.
My
Go
name
ahead.
is John Jaramillo, I'm the father.
Good morning, Mr. Jaramillo.
And I'm Gladys, I'm the mother.
Good morning, Ms. Jaramillo. What is it you want the court to know?
Oh, I just want you to know that Nicholas is the youngest boy of family of four. The oldest graduated in the university. They now study. Nicholas is an A student in FIU. He's ending the major on sociology. He's a very good kid. I'm not a victim here. I just having an argument with him because he has an argument with his girlfriend. I got very mad. I taken him home. He want to get out of the car, and we forced to get him into the car, and that's when they call the police, and they say he's abused me or not, but I'm not a victim. He doesn't work. He just study. We support him with his career. He's finishing right now.
I'm sorry, you're saying he doesn't work?
No, he's a full-time student.
Okay.
At the FIU, and that's who we supporting him to finish his career. He's now ending and he's a very good boy. The only thing that we're asking you is let us enjoy our Christmas together. He's an excellent person. We never been in this situation before, and I asking you for.
Mr. Jaramillo, can you see your parents?
Well,
Can
yes,
you
ma'am,
see
I
your
can.
parents?
Of course.
You see them
This
right
has
now.
never happened. My parents are my best friends.
I'm just making sure you can see them at this right now.
Of course, I feel the same way. None of us are happy about the situation. It was a misunderstanding between my father and I, and
It says drunk about 3 times in this probable cause affidavit, sir. I don't know if those are misunderstandings or not. What say you, Ms. Davis?
Your Honor, Kesha Davis will stay will be asking for $1,500.
Ms. Chase, I can't hear.
The state will be asking for $1,500 on each count, no victim contact on both counts, a substance abuse evaluation, and all follow-up treatment, Your Honor, at this time, and anger management classes within 10 days.
Ms. Chase?
Judge, I just like to mention, I know that the parents mentioned he is a student at FIU full-time. He also informed me he just made Dean's List. And I believe he has no priors, no arrests. In terms of the request for substance abuse evaluation or monitoring, I believe this is an isolated incident. I don't think it's something that's going to require that extensive supervision or monitoring. I fully believe this sounds like an isolated incident. Like I said, he's a student full-time. He made Dean's List. He doesn't have any other arrests involving alcohol or this type of behavior.
Okay. Thank you very much. Mr. Jaramillo, I'm going to set your bond at $1,500. I'm going to order that you are not to have contact with the victims in this matter, Carolina Urbano and John J. Jaramillo. I'm going to order that if you have belongings at the home located at 17382 Southwest 18th Street, Miramar, Florida 33029, that you get a police escort to retrieve those belongings. While you're on your supervision, you are to attend at least 3 12-step meetings a week. You are to undergo an alcohol evaluation and any follow-up treatment. You are not to have any alcohol whatsoever while you are on supervision. And that's it.
Judge, it is my understanding that Mr. Jamario's parents do wish to have contact with him.
I only show one count. Oh, that's the one. No, I'll ROR on the second count.
What is that?
I'm writing it down right now. Thank you for reminding me. So, what, Ms. Davis, do you want to speak any further with the victims regarding the contact issue?
No, not at this time because of the fact that they were actually taking him away from the situation, and his dad was talking to him why he couldn't have done what he did, and said and struck his dad. At least until he gets some form of substance abuse help before he's able to have any contact with his dad. I have no issues with the mom, but the dad was trying to be a mediator. They were driving away from the alleged incident, and he still felt it was necessary to attack his dad.
He was trying to calm the situation, but it's not like
no,
permanent thing. It's never happened.
I'm sorry, I understand your objections. You can raise those with the judge with whom this case is filed, but my ruling stands. Thank you very much. Robert Herzog?
Your Honor, Mr. Herzog is represented by private counsel,
Okay,
a Miss Roxanne Fuentes,
okay,
and she would like to appear by phone as she cannot be here this morning.
okay, sure. Okay, Mr. Herzog, do we have a phone number?
I do, Judge.
Mr. Reedy?
I'll just leave it on.
It's 786-859-6815, and it's Roxanne Fuentes.
Thank you, sir.
Hello, you reached Attorney Roxanne Fuentes. Please note I will be out of the office from Monday, December 23rd until Tuesday, January 7th. If this is urgent or if you need to make an appointment with me, please contact my office at 376-686-0968. I want to wish everybody a happy holiday and a happy new year. Hola, antemado la abogada Roxanne Fuentes. Voy a estar fuera de la oficina desde el lunes, diciembre 23, hasta el martes, enero 7. Si es urgente o si necesitas hacer una cita conmigo, por favor, llama a mi oficina al 786-686-0968. Feliz Navidad. Bye-bye.
At the tone, please record your message. When you have finished recording, you may hang up or press 1 for more options.
Good morning, Ms. Fuentes. This is Judge Betsy Benson. I'm calling you as I understand you represent Mr. Robert John Herzog. We are commencing with his first appearance hearing, and I was told that if I call this number, since you're not here, we will go forward with the hearing. Thank you. Okay, Mr. Herzog, your lawyer is not available. I've tried to reach her. You are charged with violating an injunction against repeated violence. I do find probable cause. Mr. Linder, what say you as to bond?
Your Honor, Ms. Davidson's going to be making recommendations. I just want to I think the court should be aware. I reviewed the petition seeking the injunction. The petitioner's making claims that essentially they have a child in common, the relationship ended. She made it clear she had no interest in anything other than co-parenting. Mr. Herzog has been unwilling to let the relationship go, constantly contacting her, showing up at her place of work, driving by where she lives, which is concerning the petitioner because she has no idea how he knows where, even in public, when she's out with other people, how he knows where she is. She does mention at one point her car was keyed, and why she believes Mr. Herzog was involved was what was keyed into her car was a term that they both share for their son. She's filed police reports, and that's what led to her seeking the injunction. She filed for the petition first week of December and says this has been going on for 3 months, and I'll let Ms. Davidson proceed.
What are your,
Judge, I have Ms. Fuentes on the line.
okay,
If you want to call her right back, she's available right now.
okay.
All right, the judge is going to call you. You're very welcome. What's going on, Bond?
This is Roxanne.
Yes, good morning, Ms. Fuentes. We are here in the matter of Robert John Herzog. My name is Betsy Benson. I am the judge who's presiding over his magistrate hearing. He is charged with violating an injunction against repeat sex and dating violence. I do find probable cause. I'm taking testimony as to release. Mr. Linder has just outlined issues regarding the injunction violation. And I'm turning now to Ms. Davis to indicate what your recommendations are, ma'am, as to bond. Okay. What say you, Ms. Fuentes, as to bond? She has recommended a $1,000 bond with a level 2 GPS monitor.
Well, the thing is that they have a custodial, he has custody rights to his son. And so we were in court on Friday regarding regarding the temporary restraining order, which was extended. And the judge told him that he was able to communicate with his ex regarding visitation, regarding complying with his visitation rights under a family law case. And so that's what I instructed him to do, as far as, because he needs to be able to see his son under the visitation that he currently has. So I believe that that's the only communication that he was having with her. He does get FaceTime opportunity to FaceTime with the minor child once a day, and he does have visitation for Christmas Eve and Christmas. And so when we were in court, the judge said that he was allowed to communicate with her solely with regards to the minor child, and that he wouldn't be in violation.
Who was the judge?
Hold on, let me get you the, it was Judge Cohen. Judge Dale Cohen.
Dale Cohen, okay. And but Judge Dale Cohen is not the injunction judge. Dale Cohen is the family judge.
Well, that's who we went in front of on Friday. That was who we had the hearing with Judge Cohen. And he because I had asked him, I said,
hang on. I understand that you're telling me what he said, but I want to see what's reflected in the order, and I would think that the order would specifically carve out this exception.
Oh, I'm going through that, Your Honor.
Yes,
I just want to answer
Mr. Linder has the order on his screen, Ms. Fuentes.
I'll print a copy
We had
for you.
asked him about that, and he said that because the restraining order was not, the minor child was not listed in the restraining order that's currently in place, it's only with regards to his ex-girlfriend, that he was able to communicate with her solely for the exchanges in the custodial arrangement that they have, and that was it.
I don't see how any kind of communication with the petitioner on an injunction is allowed unless the judge specifically states on the order that it's allowed. So I'm concerned about that. Mr. Linder, are you reviewing the order?
I'm printing you a copy for Your Honor right
great.
now.
I believe, if that hearing was recorded, which I think all the hearings are, there should be a transcript where the judge says that in the hearing.
Well,
But he didn't.
I'm looking forward to receipt of that, Ms. Fuentes. Did you get a copy of the transcript?
I did not. We just went on Friday, and I'm on vacation for Christmas, so I wasn't able to obtain it. But I don't know if you have access to the transcript, but
No, I don't.
know he specifically said it in open court.
Okay, so you all have provided me with the injunction, the order on the injunction. I was looking for Judge Cohen's order from Friday. Do we have an order from Friday?
No, Your Honor. Your Honor, when I did a search under DVCE-19-8709, the last document that was uploaded into Odyssey was Ms. Fuentes' motion for continuance, and that was dated to continue the hearing set for December 20th, last Friday.
So we don't have any order from Judge Cohen from Friday.
Not in Odyssey, no.
I do have one. They gave us an order, but it was just an order extending it to June and scheduling a status conference for June.
Right.
Because the petitioner was saying that she was going to dismiss it, which apparently she hasn't.
I'm not inclined to follow your recitation of what occurred on Friday, given that there is no order specifically addressing this issue. And if you follow the logic that, because they have a kid in common, they can talk about the kid, that would eliminate the need for third parties to supervise visitation. And we've got a whole program of third parties that supervise visitation. So
What they had been doing, when the order was in place, what they had been doing with regards to the exchanges is they have been doing it at the police station. And she was going to the police station, meeting with him, exchanging the child. She was speaking to him at the police
well,
station.
there's an injunction does not stop the petitioner
Right, I
from
understand that. I
communicating
understand.
with the defendant. Only
I
him. And this indicates that there are text messages, there are numerous text messages sent regarding, you're correct regarding the child, but I just don't understand why there isn't a third party in effect, considering that there's apparently a history of contact that she listed in her petition for the injunction. Mr. Linder, do you want to indicate what she's called the police numerous times in this matter?
And Your Honor, the only other thing I could tell you that was mentioned that doesn't make sense to me, and I believe it was brought up that the reason the child wasn't addressed in the temporary injunction is because there was no information about that. I can print you the copy of the petitioner's petition, which states, we have a child custody agreement in place with the courts. She
So that's-
specifically references their child in the petition.
So I am going to find probable cause and place Mr. Herzog on a level 2 GPS monitor. Order again that he have no contact whatsoever with the victim. He has to go through a third party until he gets a court order that specifically states that how they are to manage the custodial situation. I can't imagine something as important as a child is not addressed in an order. So, given that, if you go to Judge Cohen and you get the order and address this before Judge Cohen, that's fine. But for today, he's on a level 2 GPS monitor. He's to have no contact for any reason until further order of Judge Cohen regarding the minor child. And anything else? While you're on the monitor, you can go to work and go home. And any other court authorized activities. No bond requirement? $1,000 bond. Thank you very much, Ms. Fuentes.
Thank you.
Corey Naismith. Good morning, Mr. Naismith. You are charged with violation of an injunction against domestic violence, throwing a deadly missile into a vehicle, or I think it's into a dwelling in this particular case. And that is part of case number 19-13649 CF10A. You're charged with burglary with a battery in 19-14528 CF10A, and you're charged with a domestic battery in 19-14528 CF10A. What say you, Ms. Chase?
Your Honor?
I do find probable cause.
Your Honor, if I could address count 3 first.
Certainly.
Thank you. Count 3 is a burglary with a battery, and it involves a car. And I know that while that is not as serious as someone breaking into someone's home, I am going to be seeking a finding of proof evident or presumption great in that Mr. Naismith be held no bond in that charge. If the court finds that that standard is satisfied, I'd further be asking the court not to exercise discretion in setting a bond. Frankly, I just believe Mr. Naismith just poses a significant danger to this woman. If the history of events, Your Honor, is In October of this year, the victim sought a petition, an injunction. She was granted an injunction. By the time it was served, these two other incidents occurred. The missile into the vehicle, I believe it was a brick or a rock, and then the burglary with the battery, in a battery that's happened while her child was present in the car. Then after both of those incidents, he then violates the injunction by going to her place of work where a law enforcement officer happened to see him at her place of work, where he was ordered by a judge, and he was hand-delivered the permanent injunction in court that is in place till December of next year, and he signed it agreeing to it, and it is clear that he has no intent of leaving this woman alone, and it's not just harassing behavior, but violent behavior against this woman.
Ms. Chase?
At this point, Judge, I don't know as to count 3, if the state's seeking for a finding of proof evident presumption grade, I'm not sure where.
You're not sure what? I'm sorry?
Well, Judge, at this point, I know that he rents an apartment, he pays rent, he's full-time employed at a fast food restaurant, and provides support for a 3-year-old daughter. I think his only priors are juvenile priors. I'd ask the court just to consider this in terms of setting a reasonable bond. He does not have any money in the bank at this time to post bond.
Okay, thank you.
I would object to any finding of proof evident presumption grade at this point, Judge. As Mr. Linder did point out, it may not be as serious as a burglary of a dwelling. It is not. I understand that he grabbed her arm and punched her while she was inside the car, according to the probable cause affidavit, but I would ask the court to exercise its discretion and set bond for Mr. Nesmith. I also note in the probable cause affidavit in relation to count 1, it appears that a restraining order was granted, but that Mr. Naismith had not yet been served.
Okay. And I see we have a witness. Good morning, sir.
Good morning, Your Honor. I'm the bondsman as well, just present here, but I did speak to his mom, Tracy, who's currently in the hospital. She got rushed to the hospital and had a child because of high blood pressure yesterday. I did speak to the victim as well, but I can't too much speak on the fact. I know she just wanted to make sure that he did stay away. I explained how serious the case was. She, at that time, told me she didn't want to see him stuck in jail because they do have a kid, but she does want him to stay far away from her, and that's what she relayed to me. Okay. But I know the family doesn't have much money. He does work, like she said, at Chick-fil-A, and the family is limited on funds.
The proof evident presumption grade, I will defer to the division judge on that issue, but I will set bonds in the amount of $50,000 on counts 1, 2, and 3 for a total of $151,000. If you are able to make your bond, I will place you on a level 2 monitor. You are not to have any contact whatsoever with Estefany Morales. You are not to go within 500 feet of 261 Northeast 30th Street, Pompano Beach, Florida, 33064, as long as she is living there. And you're not to go within 500 feet of 480 East McNabb Road 2, Pompano Beach. No, that's you. The Chick-fil-A in Fort Lauderdale. Yeah. And what is the location? At 2929 North University Drive, Suite 201, as long as she's working there. If you do have, I don't think there's any issue regarding property at the residence. You are to commence an anger management class within 10 days of your release. Anything else?
I think you covered it, Your Honor.
Okay. Thank you very much, Mr. Naismith.
Your Honor,
Are we just ordering that set address for him not to return to? It's my understanding the victim doesn't live there. If the victim is not living at the address.
That's what I indicated, as long as she's living
there.
there.
He could live there. Okay. Just wanted to double check. Thank you.
And frankly, Your Honor, maybe to simplify this, I would ask that the court's no contact order cover whatever he's been ordered by the injunction that was issued.
Right. I do adopt the injunction, and any failure to abide by the injunction to which I understand you signed when you were in court would also be a violation of the release conditions in this case and violate your release in this case.
One of us had yes and one had no, so I wanted to clarify.
Let's call it a yes then.
Yes to the GPS.
Yes. Todd Raymond Porter.
North Broward.
Okay. North Broward. Good
Good
morning.
morning. Good morning. Happy holidays to you.
You too as well.
I go by Tasha. I'm transgender.
Okay, Tasha. Okay.
Hang on, Mr. Porter.
Good morning, Tasha. You are charged with battery on a person 65 years of age or older. I do find probable cause. What say you, Mr. Reedy?
Judge, in speaking with Tasha, it's my understanding that he has been a resident of Florida since 1996 and has no prior criminal history. Unfortunately, he does have a disability that has prevented him from saving any money or having any money to post a monetary bond. So I am going to be asking the court to consider pretrial release for Tasha. It's my understanding that the liaison for the domestic violence court has spoken with the victim. The victim does not desire prosecution, and the victim does want contact with Tasha.
Okay, thank you. I do find probable cause. I am going to allow you to be released on a level 2 monitor pending, I'm not allowed to say that. You are to attend a 12-step meeting at least 3 times per week. You are to have no contact whatsoever with the alleged victim, Frank Arthur Anderson. You're not to return to 506 Southeast 16th Street, number 5, Fort Lauderdale, Florida, 33316, unless you have a police escort only to retrieve your belongings. Now, all of this is subject to having another judge take another look at this, but this is your only condition. This is the only way you can get out, okay?
Okay. Christmas is tomorrow.
That's right, but unfortunately, you can obviously have Christmas once you find a place to live, but you can't go back there because the way it's outlined in the arrest report, I don't think it's good for you to go back there right now, Tasha. Okay? That's my ruling. Thank you very much. ROR, level 2. Cameron Cordell Butler. You have Mr. Good morning, Mr. Butler. You're charged with failing to appear in traffic case number 1918573 TC40A. What say you, Mr. Linder?
Your Honor, Mr. Butler has, looks like over $100,000 in bonds and other charges, so.
Oh. All right, so your bond is $500. Thank you, sir. Daryl Tabor? Morning, Mr. Tabor. You're charged with failing to appear in a couple of in a municipal ordinance case and a misdemeanor case. The municipal ordinance case is
Alcoholic beverage violation?
a beverage violation. What's the misdemeanor case, Ms. Chase?
It looks like a trespass. But
Okay.
in speaking to Mr. Tabor, he indicated he had pled cases out at magistrate court recently. I'm just wanting to verify. I don't have a computer here to verify that these weren't resolved.
Mr. Linder, you see that?
Oh, no, well, I'll let you know in a moment. Yeah, he resolved a theft in July.
Great. You're right, Mr. Tabor.
No. He resolved
A theft, not this theft.
There's no theft here.
Is there a chance? It's a trespass.
These cases are both still pending.
Okay, we think you might have them mixed up with other cases, Mr. Tabor, but if you want to work them out now, I'll withhold adjudication, order that you not return to, anybody?
It is Auction House Gallery Consignment
Okay.
at 1440 Northeast 26th Street in Wilton Manors.
Okay. So you went to, they're alleging that you were told to leave the auction house gallery. It looks like a movie theater. You remember that place?
Yeah, I fell asleep there.
Okay, so I would order that you not return there, and I would take judicial notice of the time you've served on both of these cases and withhold adjudication, and you would be released if there's nothing else holding you.
That's it. Thank you, Your Honor.
Okay, then that's what I'm going to do. Happy holidays to you, Mr. Tabor.
Same to you, ma'am.
Have a good day, Daryl.
Oh.
Thank you, Judge.
Sound good? Where can I find a drink of water around here?
They're in charge.
I'm waiving his court fines.
Thank you, Your Honor.
What's your name, sir?
Mr. Coleman. Good morning, Vernon.
Vernon Coleman. Good
Yes,
morning,
Judge.
Mr. Coleman. You're charged with violating a municipal ordinance. Which
Open
one?
container,
Okay,
Your
so Mr. Coleman, if you want to resolve your case today, you can plead no contest, and I'll take judicial notice of the time you've served, withhold adjudication, and waive your court costs.
Yes, ma'am. No contest.
Okay, that's what we're gonna do. Can you come to City Hall on January 8th, and we'll see if we can get you some resources and help you?
Yes, ma'am.
All right, you're coming to City Hall on January 8th, right?
Yes, ma'am.
11 o'clock in the morning,
Yes, ma'am.
and we'll see if we can get you some treatment and some help, okay?
Yes, ma'am. Thank you.
All right, see you
Merry
then.
Christmas, Vernon.
Okay, thank you.
Okay, Roger Lee Leninger.
Morning, Roger.
Good morning, Mr. Leninger. This is Judge
Good morning.
Benson. You're charged with missing court on 3 different municipal ordinance charges. What are they, counsel?
Judge, it's actually 2 cases. The first
Oh.
case is solicitation on a roadway, and the
Okay.
second case is an alcoholic beverage. It looks like he was placed on pretrial release for both cases, and this was mostly a violation of pretrial, and he didn't show up to his arraignment. So,
Okay.
I'm not sure why he was placed on pretrial, though.
Yeah, I'm not
I
either. Why
believe-
can't he go? Oh.
Yeah.
I
But-
don't live there, ma'am.
Right,
So-
but I would ask Your Honor to allow him to resolve them both.
Okay, so, well, I can only resolve one. BSO tells me the other 2 are not for me.
So what happened with count 3? What happened? Right, so, but
Well, count 3 was RR.
he was ROR'd already? With-
Yes, but it was still not the magistrate. He is RR.
Okay.
Count 2 is not.
But counts 1 and 2 are the same case number, so even if we were to resolve count 1, it's the same case number. And Judge, I mean, even though count 3 is not for magistrate, you are able to still resolve it. We have a case number, so if you're inclined to allow him to do so, you
Certainly
can.
am. I'd rather
Otherwise,
go
he's
ahead
just
and...
gonna get a KPS for not showing up to court in the
Okay, so
future.
I am inclined to resolve it. Mr. Leninger, can you come down to City Hall on January 8th, and we'll see if we can get you some help with medical and housing and everything?
He used to be a part of community court, but his cases were transferred back to
'Cause he-
traditional court because he wasn't participating.
Okay, so Mr. Leninger, if you want to resolve your cases, I will sentence you to the time you've already served and withhold adjudication and take judicial notice of that and waive your court costs. You want to do that?
Yes, ma'am. I'd like to solve it, yes.
Okay. All right, so that's what I'm going to do. Sentence you to time served. Well, take judicial notice of the time you've served and waive your fees, okay?
Yes, ma'am.
And ask you to come down to community court on January 8th. I know you don't want to come, but I'd like to see you.
You can still come.
You can still come. Will you come to City Hall?
You've been there before. Just come back.
Come back to City Hall on January 8th.
Okay?
Yes, yeah.
So Judge,
And
you
that-
are withholding on 1, 2, and 3.
Yes, ma'am, I am.
Will I
Waiving the
get
court costs.
a paper on it?
You'll- I'll ask Ms. Chase to give you a paper.
Thank you, Judge.
We should have flyers here. We should have flyers in there
In the
for
courtroom?
that, yeah.
That'd be great. I could I can talk to them about
I
that.
would really
That's kind of a
appreciate
good
it.
idea, actually.
Thank you.
No problem, Judge. I'll look into it.
Okay, James Laurie. James Laurie.
President Angel.
Okay, Mr. Laurie, your bond has been posted. Santana, Michael Santana.
Says counts 2 and 3, Judge, or City of Hollywood.
Is there anybody here from the city of Hollywood to prosecute these cases?
No, Judge.
Nope. Morning, Mr. Santana. You're charged with trespass in count 1, and you're failing to appear in 2 municipal ordinances on counts 2 and 3. As to counts 2 and 3, I'll sentence you to time served if you want to plead no contest.
It's no contest.
Okay. I'm going to
How
take
are you?
I'm good, sir. Thank you for asking. I'm going to withhold adjudication, take judicial notice of the time you've served, and waive your court costs and fees. Is that what's up with count 1, counsel?
Madam Public Defender.
Babes,
Right.
almost.
I'm waiting for you to tell me what you want me to do.
Oh,
with
counts
count
2 and 3 were mine, Your Honor.
Oh,
She's talking to him on count 1.
you're Hollywood. I didn't know you were Hollywood.
Yeah, Steve covers those as well.
Oh, I didn't know that.
That's okay.
Well, you did a great job for him. Just so you know. I'm waiving court costs.
Thank
Is it possible he can resolve the first count as
Yes,
well? Judge?
sure is possible. Mr. Santana, if you promise me you won't go back to Swifty Coin Laundry, I'll withhold adjudication. No return to Swifty Coin Laundry, okay?
Yes, ma'am.
I'll take judicial notice of the time you served and waive your court costs and withhold your adjudication, okay?
Yes, ma'am.
You take care, sir.
Have a good day.
Thank you, Judge.
Thank you, ma'am.
Your Honor, may I call one out of turn? I have only one left, but it's on page 16.
No, because I'll
No?
miss you.
Okay.
Leslie Smith.
She said no. Okay.
Where's Mr. Smith?
North Broward, Judge.
Thank you, sir. If you come find it in the pile, I'll do it. Leslie Smith.
He's a medical research on.
All right, thank you very much, Deb.
You're welcome. Bernice.
Luclece Verness.
No problem.
Good morning, Mr. Verness. You're charged with additional counts, I believe, from another case. Case number, count number 13 is petty theft. Well, actually, it's enhanced because the person was 65 years of age or older. Fraud on a person with 65 years of age or older. Grand theft on 65 years of age or older, and fraudulent use on a person 65 years of age or older. What say you, Mr. Linder?
Your Honor, Mr. Verness has no bond holds on other counts, so I was just gonna be asking that these bonds be kept in place.
That's fine.
Okay, I do find probable cause. Your bond on count 13 is $3,500, count 14 is $1,000, count 15 is $3,500, and count 16 is $1,000. Thank you very much, sir. Jerry Baker? Mr. Baker?
And
Good
Judge, I'm
morning,
only-
Mr. Baker.
Only asking to be appointed on count 2.
Okay, as to count 2, I will appoint the office of
Steve Shate.
Mr. Shate.
Yes.
As to count 1, grand theft auto. Count 3, violation of pretrial conditions. And count 4, violation of pretrial conditions. And count 5, driving while license suspended. Well, count 3 and 4 are not for magistrate. Count 5, driving while license suspended. I do find probable cause. What say you, Mr. Linder?
Your Honor, in light of the fact that among the allegations before the court are allegations that he was not compliant with pretrial, I'm asking that the bond on count 1 and 2, count 1 be kept in place.
Okay. As to count two, what say you, ma'am?
Judge, I would ask for an ROR on count 2 since he already has $1,000 bond on count 1.
That's denied. I will set your bond at $1,000 on count 1, $100 on count 2, and on the driving while license suspended second offense, I will set your bond at $500. You are not to drive if you are on pretrial. If you do make your pretrial Mr. Baker, you are not to have any contact whatsoever with Latrice Siobhan Webb. You're not to go there. Go to 670, all right, I'm starting to remember this case. 670 Northwest 21st Avenue, Pompano Beach, Florida, as long as Ms. Webb is living there.
How much then? If I have the funds and nobody to buy me out, what can I do?
You can ask your lawyer to take you before your judge for a motion to reduce bond.
And Judge, I just wanted to point out at this point, he does have a residence. He has no money in the bank. He works doing temporary service jobs, but times are slow right now. The income's slow. He has 3 children, ages 2, 3, and 4. He spent money on Christmas. He's trying to help support them, and he doesn't have the funds to bail out. That's the thing, and we were going to ask the court to consider reducing that amount.
Thank you, counsel. That request is denied.
He also returned the car, Judge.
Okay, thank you. Samuel Randall, Jr. Good morning, Mr. Randall. You are charged with failing to appear in case number 19-13545 CF10A. Your bond is $1,000. Who is his judge?
Your Honor, he's got Judge Lynch. He's got $4,500 in bonds on other counts. I can tell you this is a change of charge, Your Honor. It's a technicality. He was charged with one type of grand theft originally. He actually had a second look hearing before Judge Powell after his initial arrest, and she declined to modify the bond. The bond was originally set at $1,000 as well, so I'm just asking that that be kept.
Okay. Thank you very much. Hatem Chorabi.
Conte, Your Honor.
Morning, Your Honor.
Good morning, Mr. Chorabi. You are here on an immigration hold. I'm sure that they will institute proceedings forthwith. Thank you very much, sir. I'm missing page 2 on Mr. Charles's case. Sure. Shaquem Charles. Good morning, Mr. Charles. Just give me a second, sir. Hey, I do find probable cause. What say you, Ms. Chase?
Judges, the court, at this point, I know count 1 and 2, it indicates not for magistrate. Are those failure to appear? I'm not sure what the KPS was for to advise him.
Yes. I believe it's a failure to appear, Your Honor. He has no bond holds for grand theft auto and grand theft. In light of that, I was going to be requesting a $1,500 bond on the burglary.
And Judge, I'm assuming we're not going to address counts 1 and 2. He's inquiring if the court would. Okay. As to count 4, I'd ask the court to set a nominal bond, given that he's going to be held no bond on counts 1 and 2.
Okay, thank you very much. Your bond on count 4 is $1,500, and your bond on count 5 is $100. Thank you, sir.
Okay. You're going to go to judge.
No staples. I don't know if you need the full PC or not.
Seriously? Like, if you know that that's what you're doing,
I cannot read Mr. Butler's PC.
If I may, Your Honor.
Yes.
Okay. It reads as...
Mr. Dwayne Butler,
Oh, yeah,
Ms.
I'll wait.
December, I'm sorry. Go ahead, Mr.
Yes.
Linder.
I'll just wait till he gets up here so we can hear what I say.
He's here.
Thank you, Your Honor. On December 23rd, 2019, at approximately 10:40 hours, 10:40 in the morning, while Customs was clearing passengers on Majesty of the Seas, officer inspection on each passenger, arrestee Butler became boisterous, and
Uncooperative.
He was then asked to enter a secondary clearance, at which time he grabbed Officer Gomez's right hand, scratching, I don't know what that second word is. Other officers attempted to gain control of Butler, and he continued resisting, causing
Officer Chase.
elbow injury. He was taken into custody, and then
Transported to jail.
See, we were able to take it together.
What say you, Ms. Chase? I do find probable cause.
Judge, at this point, I understand, he would be relying upon his parents to help post bond. He doesn't have any money in the bank. I don't believe he has significant priors. And also, Judge, I'd be asking for a photo order.
You granted?
Your Honor, I'll be requesting a $2,000 bond. It does not appear that Mr. Butler has ties to the community. I'm showing he resides in Maryland, and I would imagine, considering he was exiting a cruise when this occurred, that while it may not be his direct finances, he does have access to certain financial resources.
Okay.
Oh, and Your Honor, considering it's all subsumed in the same incident, I would be fine with an ROR on 2.
Judge, would the court consider $1,000 on count 1 and ROR on count 2?
Mr. Butler, I'm setting your bond at $2,000 on count 1 and RORing you on count 2. Thank you. Andrew Philip Pennant.
No problem, John.
Thank you, sir.
I'm out.
Good morning,
How you
Mr.
doing? Happy
Pennant.
holidays.
Happy holidays, sir. You're charged with burglary with a battery, criminal mischief, and throwing a deadly missile into an aircraft.
A missile?
It's a legal term.
Rocks at a window.
And Your Honor, I provided Mr. Reed.
I was defending myself when you had
Don't
a
say
rock
anything
over
about
there.
the case, all right, Mr. Pennant?
Yes, sir.
Your Honor, for the record, I provided Mr. Reedy with a copy of the reports that I just provided you. In full candor, I do believe the deputy's original report was conclusory in nature, so I wanted to be able to provide, Your Honor, Mr. Reedy, allegations with more detail to them. And also a report that indicates how Pennant was identified.
Okay, thank you.
Yes.
What say you, Mr. Reedy?
Well, the language on page 5 concerns me, Judge. The first line of page 5.
Yes.
I don't know what the state exactly is asking for on this.
Your Honor, I am taking into consideration the information provided in the reports regarding Mr. Pennant's condition.
Yes, sir.
And that is why I'm not seeking a no bond at this time. What I would be requesting for, considering this was someone's home, $10,000 bond on count 1, $5,000 bond on count 3, no victim contact, pretrial release of the GPS monitor, and that as a condition of his pretrial that he seek and receive a mental health evaluation and all follow-up treatment.
Thank you very much. As to count 1, I'm going to set your bond at $10,000. As to count 2, I'll leave the bond at $100. And as to count 3, I'll set the bond at $5,000. You are to be placed on a level 2 monitor, and you are to undergo a mental health evaluation and any
Will I be able to go to
follow-up
work?
treatment. Yes, you may go to work and go home. Absolutely, Mr. Pennant.
Okay.
Any a mental health evaluation and any follow-up treatment as a condition of your release. Thank you very much, sir.
Thank you.
Trevon Demps. Trevon Demps. Oh, good morning, Mr. Demps. I'm sorry, I didn't realize you were at Maine. You are charged with count 1, burglary of an occupied dwelling, count 2, battery, and count 3, criminal mischief. I do find probable charge. What say you, Ms. Chase?
Oh, Your Honor, I'm
Yes,
sorry.
sir.
For the record, I think this should be burglary of an occupied structure. So I think
Oh,
it
yeah.
happened at a Checkers.
Yes. Okay, I do acknowledge and modify the charge on count 1 to burglary of an occupied structure. What say you, Ms. Chase?
Chief, the information that I'm having is that Mr. Demps, I am unaware of prior history. He's currently not working and does not have any money in the bank, but he's living with family who may possibly assist in bonding him out. We're not sure how much they could afford. I don't know what the state's requesting, but I asked the court just to consider his financial situation's a little grim unless family's willing to help out. He's unsure what they may have to help him out with.
Your Honor, I see nothing as an adult. I would argue it would appear that he acted in concert, but I would acknowledge the two other suspects were certainly more culpable. In light of that, I'd be asking for a $2,000 bond on count 1, Your Honor. And I've seen no return to this.
Mr. Demps, I'll set your bond as $1,000 on count 1, $1,000 on count 2, and $500 on count 3. I'm going to order you not to return to the Checkers at 3451 Northwest 8th Avenue, Pompano Beach, Florida. You're not to have any contact whatsoever with the employees of Checkers. You're not to have any contact with, they don't state the full names, but the nicknames are Maine and, where's the other one? What's his name?
It says known as Paris.
Paris. No contact with Maine or Paris while this case is pending, okay? They made a lot of trouble for you, Mr. Demps. Okay? Under Florida law, if you're in a car with somebody and they do something bad like that, you can be charged as if you did it yourself. I'm sure Ms. Chase has explained that to you, right? So, no more contact with Maine or Paris. Good luck to you. Anthony Seeley? Is Mr. Seeley with you, Ms. Chase?
Yes, Judge, he's approaching.
Okay. Good morning, Mr. Seeley. You're charged with petty theft as a third or subsequent offense. You're charged with resisting officer without violence, you're charged with violating your probations in case number 18-5245, 18-11781, and 19-2005, and 18, no, that's the same one. Okay, you're going before the judge on the VOPs on December 26th at 8:30. I do find probable causes to the other charges. Your bond on count 1 is $750, and your bond on count 2 is $500. Thank you.
All right.
Joshua Newton?
And approach, Your Honor?
Yes, you may.
I imagine you don't have a PC attached?
I have warrants.
Yeah.
I have a PC on count 1.
Is it for the short arrest? Is it for the, I think that's for the basis of the arrest.
Yes.
Not the underlying.
Okay. Yeah, sorry. Okay, Mr. Newton, you are charged with driving while your license is suspended, failing to wear a seatbelt, grand theft, and burglary, and then you have warrants out of Punta Gorda.
Oh, warrants out of where?
You're not
I don't
sure?
think they attached, Your Honor.
Uh-huh.
No warrants.
Okay, so they're not part of this magistrate. I show that you have, that a teletype check shows that you have, is this Mr. Newton? Yes. Felony warrant out of Punta Gorda, Florida, for burglary of a conveyance and grand theft.
Well, the burglary, conveyance, and grand theft were the Broward charges.
Okay.
As far as a warrant out of Punta Gorda, I can tell you at this point, it doesn't appear that if it does exist, it hasn't attached.
Okay.
Because there's not an active hold from another county on it.
Okay.
Is that correct, Sheila?
It shows the warrant was confirmed and it gives a warrant
Oh, yeah,
number and
yeah.
extradition was confirmed.
And it could, still happen, I suppose. Yeah, the only warrant, Your Honor, I just checked and confinement confirmed also. The only warrant is the one that he was arrested on and not in custody out of Broward.
Okay. All right, I do find probable cause as to the burglary of the conveyance and grand theft. What say you, Ms. Chase?
Judge, in speaking to Mr. Newton, at this point, he is employed as an event coordinator. His mother lives local and his grandmother. I don't believe he has significant priors. I think at this point, he doesn't have any money in the bank. He would be hoping his mother could bond him out and may be able to afford $100 and help bond him out. We were hoping that we could get an ROR on count 4. And
What say you, Mr. Linder?
Your Honor, one concern I have is I see a Punta Gorda address on the booking and on the short arrest form, so I don't know if he resides in the Tri-County area. I do see over the past several years in Broward, he's been arrested on more than one occasion on a capias. Not necessarily significant charges, but there were issues with showing up in court. Your Honor, I would be seeking a $1,500 bond on count 4.
Okay, so I will ROR you on count 4. I'll leave your bond at $1,000 on count 3. You will be placed on a level 2 monitor. You're allowed to go to work and home.
But Judge, if he does reside in Punta Gorda, I'm not sure that he's going to be technically able to be released on that.
He's looked at me several times as if he does not even know where it is. When I mentioned Punta Gorda, he said, "Where is that?"
Well, in regards to the warrants or the KPS, he wasn't understanding what that was about.
I don't.
But that's why he was shocked or confused.
Sorry about that.
But he does have his mother local, and as long as they have the correct address, which we could file a change of address to make sure that he gets notice.
Yes. What's that?
Well, why doesn't he just tell us his address now and the clerk will take it down to make sure he gets notice?
Perfect. You want to give them your address?
Yes, 1236. Where it's the address here is 2420.
No, the address where you're going to get your mail and receive your notice.
1236 /Pine Circle.
Okay.
But that's where I get my mail at.
Okay, let's keep going. We got that far. What's the city?
Punta Gorda, Florida.
Okay, so you do live in Punta Gorda. You're not going to be able to live here. Is that correct? Because I don't want you to miss court. Okay, I don't want you to miss court because somebody sent your address to Punta Gorda. So I'm going to set your bond. Forget the level 2 BSO. I'm going to set your bond at $1,000 on count 1 and $1,000 on count 2. Thank you, sir.
Okay.
Just
Thank
for the
you.
record, 3 and 4?
I'm sorry, 3 and 4. 1 and 2 are not for magistrates. 3's $1,000 and 4's $1,000. 1 and 2 are not for magistrates. Okay. Thank you, sir. Nathaniel Scarborough?
Yes, ma'am.
Yes, you may. Nathaniel Scarborough, you're charged with 4 counts of burglary with assault and battery.
I thought it was 3.
3 counts. I'm sorry. Okay, I do find probable cause.
Your Honor, the state would be seeking a finding of proof evident or presumption graded on all three counts, and that Mr. Scarborough be held no bond. My concern is not just that he unlawfully entered the victim's property, but the level of violence in this case. That he struck one victim, breaking that victim's nose, struck another victim, knocking him unconscious. As far as the weight of the evidence, there was an independent witness that identified Mr. Scarborough. He knows him personally, corroborated the victim's version of events. All victims gave sworn statements identifying Mr. Scarborough, and I believe there was also video surveillance that captured the incident, corroborating their version of events.
And Judge would object to the court making a finding of proof evident presumption grade at this stage of the proceedings. The state hasn't brought that video surveillance in for the court to review to make a finding as to how accurate it is. I'd also point out that Mr. Scarborough never went inside a residence. All this took place, it appears like a fight in their front yard. I don't think that that's the kind of case that requires Mr. Scarborough to be held without bond, and I would ask the court to exercise its discretion and set bond for Mr. Scarborough. And once again, we have one side of the story here, and anytime there's a fight, there's always two sides. So I'd ask the court to take that into consideration as well.
Thank you, Mr. Reedy. I do find proof evident presumption great based on the sworn evidence that's been provided to the court. Of course, that's without prejudice to the defense to bring forward a motion to have the state prove their allegations to the extent the law requires at an Arthur hearing before the assigning judge, the division judge, and I am going to decline to set bond at this time. Thank you, Mr. Scarborough.
That's fine.
Janeet, Ronald Janeet.
Medical research on it.
Medical research, okay.
Yes, ma'am.
Thank you, sir. Antonio Simmons.
No problem.
Morning, Mr. Simmons. You are charged with
No
aggravated.
problem.
Yes, sir.
No problem.
You are charged with aggravated assault with a deadly weapon without intent to kill. I do find probable cause. What say you, Mr. Reedy?
I'm trying to read my... Oh, yes. I did speak with Mr. Simmons. He advised me that he has private counsel. I was not able to locate private counsel. And,
John,
Yes, sir.
Wait, that's the attorney talking.
yeah, hold up.
Your attorney's talking.
Let me speak now.
Well, you wait until he's finished speaking, Mr. Simmons. What
Okay, I'm
Mr.
sorry.
Reedy... It's okay.
Yes, sir.
What Mr.
Yeah, I'm
Reedy
sorry.
is saying is that you told him you had a private lawyer and he tried to find the private lawyer and he can't find him.
Okay, what happened, Your Honor, when this case began, I asked a lawyer to start a restraining order.
Okay, that's talking about the facts of the case, and I understand you want to tell me, but that's a bad idea right now. We're only here to deal with whether or not the four corners, that's just the police report as I read it, indicates that there's probable cause to hold you, and whether or not we can find a way to release you on bond or other pretrial conditions. So you do not have a private lawyer to handle your case today. So Mr. Reedy taught me how to practice law, so maybe you would let him handle your case for you today. Is that all right?
I appreciate it.
All right.
Thank you, Your Honor.
Hit it, Mr.
God
Reedy.
Judge, I know Mr. Simmons does not have financial wherewithal to post a bond. I understand that he is in a, as the court can see, he does have some physical disabilities.
Yes.
He's in
What's
a
wrong
wheelchair
with you,
at this
Mr.
time.
Simmons?
Well, I'm a disabled warrior from the United States Marine.
Okay,
I'm from
great.
law enforcement.
That's great. Can we
You know-
get Mr. Simmons transferred over to Veterans Court?
Sure.
I don't know that this is eligible.
Really?
Oh.
Aggravated assault?
Well, can somebody look into it for Mr. Simmons so we can see if maybe
I
he
didn't
can...
assault anybody, Your Honor.
Well, we
Don't
understand,
say
we
anything
understand that's
about
your
the facts of
position.
the case, Mr.
That's
Simmons.
why, that's why we have trials, Mr. Simmons. You'll be able
Thank you,
to
sir.
present that at a trial. What kind of bond can you make, Mr. Simmons?
Well, Your Honor, I was hoping that I could get a pre-release because I could have been home in my house. I'm a disabled and whatever I get, I pay my house and all my bills with my check that I get from my retirement.
Okay, great.
You know, and I keep out of trouble. I stay away from the neighbors. They're white supremacists. And they just move in. They never would have want me to move out of my home. I'm not selling my home to them. You know, and I told them that.
Mr.
And
Simmons,
continue.
Mr. Simmons, this is all a very fine argument for another day. Right now, what the court is concerned about is terms of possibly releasing you from jail. So
Yes, sir.
listen carefully to what the judge says and answer her questions, all right?
What say you, Mr. Linder?
Your Honor, I'm going to be requesting a $5,000 bond and no victim contact. I'm very concerned. GPS really isn't an option in this situation because we're dealing with two parties that are direct neighbors to one another. I do see that on two separate individuals in the past have sought and obtained permanent injunctions, orders of protection against Mr. Simmons. Excuse me. I'm getting, as far as his history, I'm getting hits under an alias, Antonio Alejandro Arrigo, this is out of Panama in 2014. Getting hits out of California, North Carolina. There have been previous arrests of a violent nature in Broward. They were dropped. Your Honor, I'm also concerned, and I have a suspicion there may be mental health issues as well, just reading over this report, just looking through his history.
Okay. So, Mr. Simmons, I'm going to order that your bond be $5,000, that if you are released, it's on a level 2 monitor, that as a condition of your release, you get a mental health evaluation, that you are not to return to your home until further order of the court. So you're going to have to find another place to live besides 4923 Northwest 54th Street, Tamarack, Florida. You're only to go back there with a police escort to retrieve your belongings. Until further order of the court, Mr. Simmons, if you can go before the judge that this case is assigned to and make a case there, that's fine. So this is without prejudice to you to raise these arguments. But you are not to.
I lived there 10 years.
I understand that,
10
sir.
years.
Unfortunately, you've been
So you
arrested
can't
for
make the white
assaulting your.
supremacists come in here and put me on
I
my
understand
property
that.
where I pay my bills.
You have
That's
been.
That's not legal.
I
And I'm a
understand, sir.
veteran that went to fight for your country.
That's the
So y'all
court's
can have a
order.
freedom of speech.
I understand. I appreciate your service.
Right.
Okay.
So can you do it for a vet?
Luis
Come on, y'all.
Guzman. Mr. Guzman. Okay. Good morning, Mr. Guzman. You are charged with four counts of DUI with damage to property or person of another, failure to stop and leaving the scene of a crash. I do find probable cause. What say you, Ms. Chase?
So he is local. He lives with his sister. He's employed in appliance repair. As my understanding is, there's no serious felonies in his history. It was some time ago, at least 15 years is what I'm hearing, that he had anything. He advised me he has about, aside from the DUI, because count 4 I understand is a second offense. But you know, at this point, he has about $400 in the bank. I'd ask the court to, you know, I know count 5 we're trying to set. I'd ask to leave it either ROR or ROR, one of the counts 1 through 4, to make it so he could afford to post bond.
Mr. Linder?
Thank you, Your Honor. I'm going to be requesting a $3,500 bond on count 5. I do believe Mr. Guzman not only presents a danger to the community based on the fact that this DUI involved a crash. His previous DUI in 2015 also involved a crash. I do believe Mr. Guzman presents a flight risk just by the nature of this offense, Your Honor, fleeing the scene. I would also be requesting, should he post bond, that he be supervised by pretrial release with a TAD monitor, no alcohol or intoxicants, and random testing.
Okay, I will leave your bond at $4,000 on count 1, 2, 3, and 4 for a total of $4,000. I'll ROR you on the counts that are for magistrates, the remaining counts. But I will order that you're on a level 2 monitor, that you have no alcohol or drugs while you're on supervision, that you are subjected to random urine testing, that you are not allowed to drive a vehicle, period, that you are on a tag monitor, that you attend at least 3 12-step program meetings per week, and that you have no contact with Jean Harold Bellevue. Is that the only victim alleged in the case?
Your
I think
Honor,
it was
that
police
he's-
officers were the other ones.
Yeah, and I think those have more to do with property damage. I think the allegation is that Mr. Bellevue is the one that suffered injuries that needed.
Okay, no contact with Mr. Bellevue. Thank you very much.
Would the court consider waiving costs for the monitor, the TAD monitor, and any other?
Sure, I'll waive costs for the monitor.
She said
Thank
ROR and all the other cases that were for magistrate.
There's only 2 more counts. I have 5, failure to stop or remain, and 6, leaving the scene of a crash involving damages. I ROR'd on those 2. Yes, ma'am. Ryan Johnson?
Good morning.
Good morning, Mr. Johnson. You're charged with strong arm robbery. I do find probable cause. What say you, Mr. Linder?
One moment, I'm just checking to see if there's any history. Ms. Hardy, do you see 20? Okay. Your Honor, I do see juvenile arrest, one similar in nature to this offense. I don't have a disposition in my Florida summary report.
Okay.
But just basing just on the allegations in this case, the level of violence alleged, and noting that the victim suffered a broken nose as a result of the attack, I'd be requesting a $10,000 bond, no victim contact.
Ms. Chase?
Judge, in speaking to Mr. Johnson, I can advise the court that he does not have his own financial resources to post bond. He's a 12th grader at Ascend Academy, so he's attending school full-time, he's not employed. He does live with his mother and his grandmother, whom he would be relying upon to help him bond out. Although at this point I'm not sure of their financial means to bond him out, I'd ask the court to consider his inability in relying on family. I don't believe he has significant priors that I'm aware of, and consider a reduced bond from what the state's requesting.
Okay, Mr. Johnson, I will set your bond at $1,500. If you are released, you are to be on a level 2 monitor. That means you can go to school and you can go home. You're not allowed to go anywhere else. You are not allowed to have any contact whatsoever with your co-defendant, Mr. Jewett, Lamar Jewett. No contact with him.
Okay.
Also, if you have any problems at home, you're coming right back to jail. Do you understand that, sir?
Yes, ma'am.
Thank you.
All right.
Okay.
Joshua Curtis. Good morning, Mr. Curtis. You're charged with count 1, possession of heroin, and count 2, possession of cocaine. I do find probable cause. What say you, Mr. Linder?
Your Honor, I'm showing a warrant out of the state of Pennsylvania from 2017.
For?
That's what I'm checking right now, Judge. That it would be for a larceny. It's limited extradition to surrounding states only.
Okay.
He's got multiple other priors in the state of Pennsylvania. Access device fraud, receiving stolen property, violation of their drug act.
While he's looking, what say you, Ms. Chase?
Understood, Judge. The concern for us here is that, you know, in terms of him having the ability to get to access his debit card, he doesn't know if it's in property or still in his truck, which the police may have possession of. So that creates a hardship for him to be able to post his bond. I'm not sure what the state had requested.
They're still looking at his priors in Pennsylvania.
Okay. Okay. I mean, we you know, in consideration of it being a third degree nonviolent, I was going to ask for ROR or standard pretrial. But again, I don't know the state's looking into his record.
Multiple other drug priors out of Pennsylvania. I suspect there's substance abuse issues, Your Honor. If the court is inclined to grant non-monetary release, I would ask that he be supervised by pretrial with random testing.
How long have you lived in Broward, Mr. Curtis?
About 2.5, 3 years. 3 years.
And what do you do for a living, sir?
I own a small construction company, residential remodeling and repair.
Okay, so I will ROR you, I'll place you on a level 2 monitor. You will have random testing for drugs or alcohol. You're not to have any alcohol or drugs while you're on supervision. You're to attend at least 3 12-step meetings per week. Okay? You're allowed to go to work, a 12-step meeting, a urine testing, or your pretrial supervision officer or court. Those are the only places you can go. Thank you. Wesley Demostine. Is he at North Broward? Mr. Demostine.
Is he a reset again?
Wesley Demostine, battery on officer.
I'll check, Your Honor.
It said reset for
He's
purposes.
a medical reset.
Okay, thank you, Ms. Chase. Simone, Mr. Peter Simone. Thank you.
Judge, I'm sorry, if I could just inquire of the court, our last Mr. Curtis, he's asking if he could just have the bond left at 1,000 per count now.
Nope.
Okay, thank you, Judge.
Alexis Simon, Saimon.
I think Mr. Simone is reset. Oh, okay. You were asking about Simon, Your Honor?
Yeah.
Or,
Saimon.
Yeah.
Thank you. Anybody?
Is he resetting?
Ms. Chase, do you have Alexis Saimon?
Judge, it's my understanding that's going to be a medical reset.
Thank you.
Can
Chin, Wayne Lincoln Chin.
Hold on, Your Honor.
Your Honor?
Yes, sir.
I was going to ask if we could reset him for the PM because he's actually on our. If you notice, if you look at the KPS, Your Honor, it's a combination of change of charges and add charges.
Okay.
A lot of the other additional charges.
We're gonna see Mr. Chin at 1:30.
Thank you,
Judge, before we make that decision, he's in Paul Ryan, Judge.
You two can't work this out without the two of you.
Well, he has private counsel.
Oh, Mr. Chin has private counsel.
Yeah, he's represented by Michael Weinstein, who is unavailable today.
Okay.
He has a hearing January 9th. I think it's a status conference. He also has no bond holds.
Okay. Your Honor, what I was hoping, if possible, Mr. Weinstein and I know each other. We've worked on many cases in the past. If I could contact him, we may be able to work something out.
All right.
You can't. He's on a cruise.
Oh, but did you reach my phone or you talked to the office?
I talked to his office.
Your Honor.
Okay.
They don't have anyone covering.
So what did he suggest, Mr. Reedy?
He suggested that the court put whatever bond the court feels is appropriate, and he can address the issue in front of the division judge on
What's your
January 9th.
recommendation for bond, Mr.
They're all
Linder?
non-bondable offenses.
Okay, so Mr. Chin, I'm going to leave you at no bond, and Mr. Weinstein is going to deal with it on January the 8th when you go before your division judge, okay?
Yeah.
All right, I do find probable
January
cause.
the 9th.
Okay.
January the 9th.
Okay, I do find.
Thank you very
All right.
much. Bye.
Thank you, sir. Mr. Jason Murray.
Coffee, Your Honor.
Thank you, sir. Good morning, Mr. Murray. You are charged with aggravated battery, and I don't have any paperwork.
Your Honor, it's another technicality. When he was arrested, he was charged with aggravated battery. The state filed it as aggravated battery 1020 life with actual discharge of the firearm.
Okay.
Bond was originally set at 10,000. He's being held no bond on a robbery firearm. So I just asked that the $10,000 bond be placed back on him.
Okay, what say you, Mr. Reedy?
That's fine.
All right, I do find probable cause, Mr. Murray. I set your bond at $10,000. Thank you very much, sir.
All right.